just to non-payment of salary. The petitioner is by the time retired next week.
On 24th.
24. Highly applied.
Back to mention for listing of a contempt matter. What are next week? Next week. May I please, Your Lordship, I beg to mention for listing to read petition, Lordship, next week, in admission column. Not 25, not oblige, Lord.
Praying for listing the matter for admission on next week.
On 27.
Connected. It was posted on 5/8/2024 after
Which column?
Yes.
Admission
For order lordship.
order.
Yes. Lordship like this for motion.
Take it. Oh, also,
Yes.
Son matter.
Yes. And one more WPC lordship.
28.
Where is the lordship? I beg to mention for listing of the contempt petition lordship for orders colon and it's ordered like
21st.
24,
21st.
24.
It is retrograde. I'd like to make a mention for listing for content.
When?
21st.
Please, Lordship, I beg to mention, Lordship, item number 19, Lordship. In this petition, Lordship, the respondent number 2 has filed an affidavit. So, Lordship, you have to file a reply. We will file it on Monday, Lordship.
Okay.
Matter will
Sir,
be
your name, please.
SN Ahmed.
The petition submits that the respondent herein has filed one affidavit and the petition will file reply to the same. And in place for this the matter after
On Friday or maybe after that.
First pickup.
Here.
Items for withdrawal. Item number 37.
May I please the lordship? Matter
Yeah.
becoming the lordship. Kindly matter.
your place.
D. Datta lordship.
He does not the petitioner submits that according to this speaking substance disposal or withdrawal.
Item number 38 for withdrawal.
Lordship similar.
Same matter. Same also. Which order is that
Highly applied.
Items for motion number 1.
May I please, Your Lordship? This content filed by Lord against my Lord. Your Lordship's order, relevant portion is page number 16, my Lord. Your Lordship has specifically directed, my Lord, the respondent authority to consider our representations within 4 months. Page number 16, Your Lordship.
Yeah.
Relevant.
that not but
Please check, my Lord.
it's the petitioner hearing is active for month of files for which then delivered by the order that is heard for the by caused by the 14th of the part. Arka petition dated 23rd that noted for it week is the
Hello.
Lordship, contempt case, relevant portion in case number 22, para 50.
hard start.
A.R. Mondo.
Yeah, and the big web of the dated or named top order past in the big or 5 order dated it
Number 3.
May I please?
I'm sorry. I
Lordship, page 13 method, relevant portion method, the last paragraph. Considering that the grievance of the petitioner has already been canvassed in the representation file before the number 219/29/11/24, is still not being considered till the report is in the interest of justice, deemed it appropriate to dispose the petition. Motion stage by itself, directed response number 2, dispose the representation dated 29/11/24.
okay, that's not it.
Fine.
Hard start.
JUNM.
Third and take the 12 of the concept of protecting it with particular it with good mind the Guwahati High Court will deliberate highly order dated 18 of post as order dated right that nothing the step it of this after
Item 4.
Wait, please, Lord. Lordship, this matter may time for password for typing. Lord.
Item 5.
May I please your Lordship? Lordship, matter relates to the pension of the petitioner, but due to some inadvertence, Lordship, I missed to annex an relevant document, Lordship, to the petition, in the petition, Lordship. I may be allowed 10 days time so that I can bring the relevant document by way of an additional affidavit, Lordship.
okay hard name
M. Borat.
and order it's order something that inadvertent enclose of the documents important document is petition and it tries for 10 days time to bring up record usage of firefighting and agriculture.
Item 6,
Lordship, I will carry that as
6 and 7.
Yes.
Items 8 and 9.
Please, your lordship. Item number 8, my lord. Here this matter relates to provincialization of service, my lord.
Okay, here, okay, go to item number, petition of item number 8 and 9. The director has already sent a proposal for creation of 2 numbers of posts for both the petitioners and for potential accommodation of the service. So the matter is pending for the government. It will go to the finance. After finance approval, it will be.
In respect of both the petitions.
Both of it. So it's in the positive direction. Process may can be fixed after 4 weeks. Process it can become both the process. It will take some time because financial approval is required.
And in my petition, I have also annexed this as last annexure. This document. Yes.
Which we learn it from. That the system and right direction. But well, that this is the state or state or better by written by the director department but of state better. It substance the director has forwarded a proposal to the department in respect of both the for and the matter will take some time, but it is in positive direction. And as a response after for according to action state and obtain up to date status of the effort. Then appraise
Apply.
Like
Number 10.
Ayok,
Counter by the sorry, item 10. This case because but after expected. Terminated in the year 2028 is subsequently fiber before the year was that actually also has rejected by now. Again, that
order is selected
sort of
completely after some time.
item 11.
Act with your lord. The petitioner by way of the present petition, your lordship, was put to challenge your lordship. A search cum selection process initiated for selection and appointment of Vice Chancellor in Assam Agricultural University. Our basic grievance is that, Your Lordship, this has not been done as per the norms laid down mandate of the UGC Act. Your Lordship will kindly come to page 1, page 26, Annexure 1. That is the advertisement issued, Your Lordship, by the registrar.
Yes.
Your Lordship has got it, Your Lordship. This advertisement here, so far as the advertisement is concerned, Your Lordship, it has been issued. And thereafter, Your Lordship, when I came to know about this, Your Lordship, being an intending candidate, Your Lordship, I have submitted a representation at page 27.
Yes.
Page 27, Annexure 2.
For?
Seeking certain clarifications for procedure of appointment of Your Lordship before the Chancellor, Your Lordship. And basic case, Your Lordship, will kindly come to serial number 1, applicability of UGC regulation 2018. Page 27, it starts from. The University Grants Commission by this notification dated 18 July 2018 issued the UGC regulation on so and so. So regulation 1.2 mandates that every university must within 6 months of the enforcement of UGC regulation 2018 amend its statutes, ordinances, and other statutory provisions to bring them into conformity with UGC regulations. To the best of my knowledge, no steps there have yet been taken to amend the relevant provision of the Assam Agriculture University Act 1968. If any such amendment is AU60 has been effected, the Honorable Chancellor's assent is required under subvention. This can be, Your Lordship, skipped. Then Your Lordship will kindly come to constitution of the selection committee. As per the UGC regulations 2018, the members of the search cum selection committee must be persons of eminence in higher education and must not be connected to any manner with the university concerned its colleges. However, I have reliably learned that the Commissioner and Secretary Agriculture Department, who is also Agriculture Production Commissioner of Assam, has been nominated as the state government's nominee in the committee. While she is an accomplished administrator, she cannot be regarded as a person of eminence in higher education. Moreover, the Agriculture Production Commissioner of Assam is an ex officio member of University Board of Management, which establishes her formal connection with KAU, thereby contravening the express provisions of UGC Regulation 2018. Now, Your Lordship, to this, Your Lordship, there is a reply, Your Lordship, by the Your Lordship will get it at page 64. This is by the registrar, Your Lordship. 63 is the covering letter, Your Lordship.
You are agreed mainly by constitution
Of the selection committee, Your Lordship, which is not as per mandate of the UGC regulation. That is, and since they have to amend it, Your Lordship, an Honorable Apex Court has very clearly held, Your Lordship, that UGC regulation is the paramount, Your Lordship. The mandate of the UGC regulation will have to be followed in case of selection and appointment of Vice Chancellor. They have not denied my allegation, Your Lordship. They have said, Your Lordship, in page 64, Your Lordship will get it. They said, Your Lordship, that since government has not amended the state has not amended the Assam Agricultural University Act, Your Lordship, therefore they will have to go by this. Page 64, Your Lordship, may kindly peruse, Your Lordship. They have also admitted that the para 2, that as per section 10(2)(b) of chapter 3 of Assam Agriculture University Act, the Agriculture Production Commissioner, Agriculture Department, Govt of Assam is a member of Board of Management of AAU. At present, the Commissioner and Secretary of Assam Agriculture Department is also the Agriculture Production Committee. So, Your Lordship, that they have said, and in para 1, Your Lordship, they have said that Assam Agriculture University has been governed by the provision as laid down in Assam Agriculture University in 1968 and subsequent amendment in 1984 passed by the Assam State Legislative Assembly. Accordingly, as per the section 9, subsection 1 of AAU Act as amended in 1986, the composition of the selection committee for appointment of a Vice Chancellor is as follows. On the other hand, by section 7.3 of UGC Regulation 2018, it was mentioned that the member of the selection committee for appointment of Vice Chancellor is to be nominated by Chairman UGC which is read as one member of the third term selection committee shall be nominated by the chairman University Grants Commission for selection of vice chancellor of the state, private and deemed to be university. So far as the regulation of UGC has not been incorporated in AU Act as amended up to date. Now they have admitted this. Your Lordship may kindly come to your Lordship, page 95 to UGC regulation. I have annexed the relevant portion, your Lordship. Page 95, your Lordship will get it bottom 7.3 clause.
Yes.
Roman 2, your Lordship. The selection for the post of Vice Chancellor should be through proper identification by a panel of 3 or 5 persons by a search cum selection committee through a public notification or nomination or a talent search process of combination thereof. The members of such search cum selection committee shall be persons of eminence in the sphere of higher education, shall not be connected in any manner with the university concerned or the colleges. Now the person concerned, one of the member which I have raised, he is a member of the board of management of the university. He was made a member of the selection committee. Going by this, your lordship, he could not have been made, your lordship. Then your lordship, search cum selection committee, this is there, your lordship. Now your lordship will kindly come to your lordship may kindly come back to page 66, my petition, your lordship.
Yes.
At the top, your lordship, 1.2 clause. Every university or institutions deemed to be university, as the case may be, shall as soon as may be, but not later than with 6 months of the coming into force of this regulation, take effective steps for the amendment of the statute, ordinances, and other statutory provision governing it, so as to bring the same in accordance with the regulation. There is a mandate of the UGC regulation itself that everything will be have to be amended so as to make it pure lordship as per the UGC regulation. Now that has not been done, your lordship. They have gone by their own act, your lordship, which has not been amended, which is not in terms of the UGC regulation. If they don't follow, your lordship, the UGC regulation, what will be the consequences? That has already been decided by the Honorable Apex Court in 2 judgments, your lordship. There are 3 judgments, your lordship. I am relying on 2, your lordship. One is
The relevant paragraph.
your lordship, you may kindly first take page para 41, your lordship. Thus, despite the communication by the UGC dated so and so, thereafter the communication by His Excellency the Governor of Gujarat dated so and so, even the observation made by Division Bench of the High Court in SSS so and so, its judgment and order dated so and so, reproduced here. It is unfortunate that even on this today, no further step has been taken by the state government to amend the state legislation and put the same at par with UGC regulations, and the state and universities thereunder have continued to make appointment of the Vice Chancellor just contrary to the UGC regulation. Now, para 44, your lordship. Thus, we find that the appointment of respondent number 4 is contrary to the UGC regulation 2018. Also, respondent number 4 has been appointed by a search committee not constituted as per the UGC regulation 2018. Moreover, respondent number 4 does not fulfill the eligibility criteria of UGC regulations 2018, namely having 10 years.
Which paragraph?
Page 44, your lordship. Next, para 44, your lordship.
Yes.
Your lordship, the Honorable Court has, your lordship, held that the appointment is, your lordship, is not as per UGC regulations. Then your lordship may kindly come to para 49 and 50, your lordship. para 49. Therefore, when the appointment of respondent number is 4 found to be contrary to the UGC regulation 2018 and UGC regulations are having the statutory force, we are of the opinion that this is a fit case to issue writ of quo warranto and to quash set aside the appointment of so and so. Then 50, it cannot be disputed that UGC regulations are enacted by the UGC in exercise of power under section 26(1)(e) and 26(1)(g) of the UGC Act 1956. Even as per the UGC Act, every rule and regulations made under the state act shall be laid before the House of Parliament. Therefore, being subordinate legislation, UGC legislation becomes part of the act. In case of any conflict between state legislation and the central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject education is in the concurrent list of so and so of the 7th schedule of the Constitution. Therefore, any appointment as Vice Chancellor contrary to the provisions of UGC regulations can be said to be in violation of the statutory provision warranting a writ of quo warranto. Now, Your Lordship, even subsequently also, Your Lordship, Honorable Apex Court in another judgment, Your Lordship, has upheld that position. Yes, yes. That I will not, Your Lordship, not burden this Honorable Court. Therefore, Your Lordship, only aspect, Your Lordship, is to concern, and they are to do, Your Lordship, by following the UGC mandate of the UGC regulations, they are required to, Your Lordship, constitute the selection committee. That has not been done, Your Lordship. Therefore, I am before this Honorable Court. The
no more raise the guidelines of over the power concurrent list central list. But the pilot may kindly, but because it is fixed for motion, not for final hearing, pilot may kindly page 26. It's an advertisement pilot dated by the 28/8/2025. So petitioner has come pilot after more than 2 months. My instructor, though my service take some time, not that in a week or so. Secondly, pilot may kindly page 32. The petitioner here has himself submitted an application for a post, right? But the same advertisement, though he has reservation or objection to that. Page 32 is the application by the petitioner for selected right. Then my lord may kindly page 27. He says that he is agreed, so he has submitted a representation. So, according to him, this representation has not been considered. My humble submission would be, my lord may even dispose of the case, my lord directly out, take a call on his, or my lord be short notice, 2 weeks notice. I will come up with whether we are complying with the or whether we are taking up any steps for correction. Let notice go, my lord, return within 2 weeks. If necessary, my lord, notice on interim goes. Because my lord, passing any interim order today, my lord, will not benefit anybody of implementing the petition. So let notice go. The notice on interim
till the decision is taken, you proceed with the process. Because you see, admittedly, you have not amended the act, and in view of the decision of the Supreme Court, this preferred by the court. What would be the consequence ultimately?
ultimately, yes.
It would be big zero. Better you take repeal measure at this stage.
But passing a stay of the selection will the finalize like that. Absolute say, my lord, will not benefit him also because he is also a contender of the postman.
I am contender, Your Lordship.
Basically, the constitution of the search committee.
Yes.
So that can be modified at any time. So let's not notice. So within 10 days, I will come up.
If the meantime finalize the process, then
the difficulty is that if there is something like in the meantime, my lord, this case will continue for years. So let it be fixed within
No,
15
Your
days.
Lordship. That will not.
continue. To come with your affidavit in opposition will finally adjudicate the
Lordship.
Let notice go.
what is to be decided here, what remains.
Okay. Or my lord, direct the authorities in terms of representation 27, page 27. Let them take it.
they have already taken, they have
They
replied.
have not taken, but
Yes,
it's wrong, my lord, because my lord will kindly fill page 27 for us. Page 27, my lord, is addressed to the Commissioner and Secretary to the Governor of Assam. And my learned friend is, my lord, referring to page 64. Page 64, my lord, my learned friend has referred, my lord. 64 is a reply before that, my lord, will see the covering letter. It is from the Register of Assam Ethical Studies. It's not the authority, my lord. It's decided by the Commissioner Secretary Governor. Because Honorable Governor is the Chancellor of the University. His representation was to the Governor.
that letter, your lordship,
Definitely,
itself, please say letter from the reference letter from the governor secretary, your
True,
lordship.
my lord. What I am saying, let there be direction to the Commissioner Secretary, to the Governor of Assam, my lord, to take a decision on by himself, my lord, on this representation. That will also suffice. If even thereafter he is agreed, my lord, they can again come. They can again come. Instead of halting a selection process to the post of vice chancellor, let the representation be decided by the Commissioner Secretary, to the Governor.
That
You proceed the recruitment process and select an appointment person.
That
Whether
will
that
never be
will
done.
stand the scrutiny of the court.
That never be done. What I am suggesting, my lord, let the Commissioner Secretary, Governor take a decision on the point raised by the petition. Till then, they will not go for selection. Till then, till a decision is taken on his representation, selection will not be completed. Order, my lord, will cover everybody's interest. But till the representation is decided by the Commissioner Secretary, the Governor, my lord, the selection process will not proceed. That will, my lord, suffice everything, my lord. Because otherwise, the unnecessary case will get delayed, my lord. The industry will be without any regular government. That there be order, my lord, from your lordship that will not finalize till the representative is decided or corrective measures taken.
better, my humble submission, your lordship, it is better to be decided by this honorable court, or if they take corrective measures, your lordship, in the meanwhile notice may be issued, your lordship. They'll let them take corrective measures, your lordship, whatever measure they want to take, and in the meantime they should not proceed,
Or
your
my
lordship. That
last submission, my lord, or my lord, next Wednesday, my lord, I'll come up on motion. That will be better. Because today I'm without the instruction. I'll speak to the Wednesday next, will come up.
Very beginning, I have stated that you have opinions.
My verbal instruction will take time. This up till February it will not be complete. But there is nothing on right.
Then the court
Wednesday,
let him apply instructions.
Lord. Wednesday.
Or the what capacity you are appearing?
Additional AC, my lord, for my lord, restaurant 3 and 4. 2 by my lord.
Anybody for the university?
I am for the university and for the chancellor.
Yeah, oh,
I am for the government too, but not.
this should be,
started copy.
your lordship, I will serve.
Part 2.
One will be Union of India, 4 is they are not present. It cannot be
As say other academic stuff and others standard higher research. So we learned oh, that the matter is on Wednesday, next Wednesday, in the motion for the schools to be obtained. There is a good allowed. It's not
like
Deep level.
quota.
president reflect the name of standing council agriculture in the
Deep level.
with the right there. If 50,000 with plot. Or the other day, I tried for staying the advertisement dated 27/11/2024.
The interview process. Moreover, the
Okay.
So, my case is a bit different. What was happened to me that I have been promoted to the vice principal of the school. Thereafter, I have been given in charge post of the principal also. And your lordship, thereafter, one letter has been given to me, that is at page number 46. Thereafter, the department itself has asked me to submit the document for the post of the principal. And without giving effect and without either rejecting or accepting the position, department has changed its position and has given an advertisement at page number 47. And to that advertisement, I have challenged in the writ petition, your lordship, that is at page number 49, that is 3923 of the 2025. Then the department has told me, okay, they will give effect to that earlier principal post notification. So accordingly, I have withdrawn this petition before your lordship. Now, another writ petition was pending. The department never disclosed this fact before your lordship, that 306 Act, prior to my writ petition, has been pending before your lordship. And all of a sudden, in that writ petition, department has taken an order that to give effect to the advertisement within 1 month, since my writ petition has been withdrawn. The ensuing order is at page number 81, your lord.
they are direct.
Page number
81, your lord. If that notification will be given to me on the very first, then I will challenge this notification also. Now I am totally handicapped. This notification is just, I am getting this notification is under the
Other lordship, they have also participated in the this
are you aware of this notification?
no, your lord. Just now, your lord.
That's no
But
problem
this,
with instruction.
your lordship, this notification is there, okay. That is of 10 October 2019. But your lordship, I have been given direction to give the documentation for the post of the principal. That is thereafter, your lordship, at page number 46. That is on 26 May 2023. Then how department has issued this notification, your lord? If this notification is there, if they are saying that the direct recruitment is barred by way of this notification, then how this page number 46 has come into effect? This is 2019 notification, and my communication notification is 26th of May 2023, your lord.
Yes. What is this?
they have also participated in the advertisement that
My situation is compulsion situation.
attending they have
No. Say if
interview.
there is already one notification in the year 2019 regarding the qualification of the principal, how can this
at page 46.
Letter dated 26 of May.
That my instruction is that we have appeared in the we have been was called for and he has appeared in uh, the principal post as protective candidate.
Your Lord, the process may be stayed at this stage, Your Lord.
Pardon?
Process may be stayed at this stage because this cannot be happened that 2019 and thereafter 2023. And in supersession of that, again, they have issued a notification for the page number 47 on
You have already participated in the process, then what purpose are staying the process?
Lordship, that is completely Your Lordship. They have changed my position. They have put me under the compulsion situation, Your Lordship. Your Lordship, on the very first day, Your Lordship has stayed the process. But I do not know how come this order has been come out that due
No,
to this.
there was confusion.
Your Lordship, that is, I think
No,
miscommunication
no,
is
no.
there.
There was confusion regarding the advertisement,
Yes, Your Lord.
date of advertisement.
On that day, I was speaking about only two notifications, that is of 2023 and thereafter 2024. The department has, without giving in effect to the notification 2023, they have issued notification of 2024, and I have filed a writ petition later on.
So because of that confusion, the order has not been updated. Again, letter is
And Your Lordship, matter may be come up on Tuesday or Wednesday so that I can take the full instructions.
okay.
Then it after prior
No, Your Lordship. This is very short matter because either I have to withdraw or either I have to contest that. So, and they have already stated that I think they have said that the person has been selected. I think.
So give final consideration to the part. Not part. And third part. Respondent number. Anybody for respondent number 2? Your name? So delivers formal learned concept for the for report 18th of September 2019. In respect of minimum of appointed the post of principal fire and he also submits that the select process created by notification dated with the date of the
Your Lordship, earlier one, that is 2023 or 2024, Your Lordship?
24.
24 is 27/11/2024 at page number 48, Your Lordship.
And that the petitioner has also participated in the said selection. That is, it says, Mr. Sarma, Garnet, that it is allowed till then. Final number cannot be when the elect by 11, 2024.
On 21st November. Item number 40. Wait, please, your Lord. Lordship, advertisement was issued for the post of assistant professor for the Department of Political Sciences, Rupohi College, Nagaon. The advertisement is at page 49, Lordship. For OBC category, I have annexed the OBC certificate of the petitioner on the additional activity. It was filed yesterday. Page 49 is the advertisement. Therefore, my lord, I applied for the post. My application is at page annexure 3, page 50, lordship. This is my application which I had applied. It was accepted and lordship. A call letter was issued, which is at page 74. Lordship.
Yeah.
Now, my lord, the appointment of assistant professor in a provincial college is guided by OM dated 24/1/2022 issued by the Department of Higher Education, which is at page 76, lordship. I have annexed the OM, lordship. As per the OM, there is a systematic. The marking of the academic will be calculated. The calculation, the procedure is given there, my lord. Accordingly, my lord, at paragraph paragraph 9, my lord, I have given the details how much I have scored, my lord, as per my qualification. At paragraph 9, at page 13. If lordship comes to page 14, lordship, my total mark comes to 70. This is as per the OM resolution, OM lordship. Now, what has happened, lordship? During the interview, I was made to know that my BA general degree would not be taken into account because it's a general degree, general course, bachelor's degree. However, lordship, thereafter I approached the Department of Higher Education, and then accordingly a speaking order was passed, which is at page 88, lordship, of the decision, by which, my lord, that 22 marks which was to be allotted for my BA general degree was allotted to me. The if lordship comes to page 88.
Yeah.
Third paragraph, lordship. Peruse the report of the principal, Rupohi College, dated 20, lordship. Third paragraph, wherein it is stated that the selection committee awarded 22 marks for BA general degree and 5 marks for HSLC examination. The candidate's allegation in this regard is hence found to be false and meaning there were lots. Actually, what has happened is that during interview, I was made to know that understand that they should not be calculated. So I had filed a complaint before the DHA, and while taking up the hearing, the principal of the who is the respondent number 4 in this case has submitted that he has actually given the mark. So if everything is calculated together without taking into account the 3 marks allotted for the interview, my lord, my total mark comes to 70. Thereafter, also what has happened, the president of the governing body expired, lordship. So no decision was taken in the entire matter was in limbo, lordship. However, I was taking information, lordship. I was
I'm right now presently appointed as the assistant professor in Sonai College, Silchar, Lordship. So what has happened, Lordship? In the last week of October, I came to know that another person has been appointed as the president of the governing body. Immediately, I inquired with the respondent number 4, and he informed me that they have already taken a resolution and forwarded the name of the respondent number 6, who has scored 65.5 marks in the calculation. It comes to 65.5 marks. Her name has been forwarded to the respondent number 2, Lordship. That's why immediately I had come to before your Lordship, because Lordship, if the respondent number, I had asked for the governing body's resolution, they denied, they did not give me the resolution also, Lordship. So I could not annex the MPUN resolution also. However, as per I am the, I should have been appointed, I should have been recommended, Lord. They could not have recommended the name of the respondent number 6, Lord. I have annexed her application for another college, which is just few months prior to the application for to this function Rupai College, Lordship. From her application is at page 89, Lordship. From the marks allotted and everything given there, Lordship, it comes to 65.5, Lordship. So in no way the governing body could have recommended the name of the number 6, Lordship. In fact, on the last occasion, Lordship had asked me to get a copy of the impugn order, Lordship. I had went to the office of the DHC yesterday also, Lordship, but they refused to provide me a copy. That's why I'm praying, Lordship, at least let the respondent number 2 bring the copy, produce a copy before this honorable court. Until then, at least no appointment may be made in regarding this specific advertisement. Lord. Only praying for that much.
That
No, I have made her a party, Lordship. If notices issued, you will get a notice.
that is a mark which you have claimed that you are entitled to. That is your statement. Unless you forget those documents awarded marked by the can the marks awarded by the selection committee to the candidates are not
Yes, Lordship, but
your claim is your statement in your report.
Lordship, yes, because these marks will be allotted as per the OM, Lordship. It has to be as per the OM, not otherwise. Lordship. Now, as per the OM,
Yes,
by the
read out getting out the there are direct then because which are not the that forward they have also been forward. That verify the fault that the process. Thereafter only so the date of that paragraph 4. Start from paragraph.
Yes.
Yeah. The part that the comment made by the governing body of the MPKG court that it is not but the proof for the post in question. Department of Selection has not been considered by the director higher education department under the provisions of the Assam College Education Act 35 and the Assam Code method of recruitment shall be made in the manner prescribed in the appointment to the post of principal shall by direct according the governing body shall not say route to 5 for the post of lecturer librarian appointment shall be made by direct recruitment with prescribed qualification through open advertisement including daily at least consecutive in respect of grade and then of the route 7 direct route 7 without all the appointment either by the direct recruitment or by promotion have been made by director on the basis of recommendations of the governing board based on the recommendations of the selection committee department of the duty constituted. B. The director can communicate the order within 30 days. C. The selection committee may hold such days by all interview for all posts as may be considered necessary. For posts for the UPC as prescribed norm, no candidates can be recruited without having the required norm. So, Lordship, the 7 A says that after the forward the recommend that then the will be verified by the director. Director only the important that paragraph 5.
My lord, that is my apprehension, my lord. The selection committee has recommended the name of the respondent number 6, my lord. Then the governing body will forward the respondent number 6 name, lord. Not my. That is my reasonable apprehension, lordship. That's why I am before your lordship.
Verified. Paragraph 5. Next paragraph. Verified. There is no student part at the college specialized college and governed by the provisions of Assam College Employees Act 2005 and Assam College Employees 2010. As per section 6 of the 2005 Act, the appointment of both teaching and non-teaching staff in the college shall be made by the director hired on the basis of selection and recommendation of governing body of the college in accordance with the rules and procedures of the government code. 2010 rules have been framed under section 12(1) of the 5 Act. As per Rule 5(1), appointment to the post of principal shall be by direct recruitment to selection. For this purpose, governing board shall constitute a selection committee which shall select a person on the basis of an interview from among eligible candidates who apply response to an open advertisement newspaper. The governing board shall recommend the selected candidate to the director who shall put order of appointment. As part Rule 70 of 2010, for posts in which the EC has prescribed no candidate shall be recruited without having recruited norm.
Yeah, my lord, it clearly says, my lord, the name of the selected candidate will be recommended.
Verify that after the forward page said that paragraph 6 is also important. The other judgment has been quoted which says that at this stage it is important. It is clear paragraph 6 may I read? So this paragraph 10 is the direction that paragraph 10. Paragraph 10 says it is needless to say that in the event the proposal for appointment against the post of not paragraph. So the paragraph 9. Paragraph 9. Accordingly, that the restriction is thereby disposed of requiring the director higher education department to examine the proposal with regard to the appointment of the post of assistant professor in the department of political science MPK college, Dibrugarh, and thereafter come to a decision thereon in accordance with the provisions of Rule 10. Then the director higher department before arriving at decision with regard to the proposal pertaining so and so in the department of political science Dibrugarh shall afford an opportunity of hearing both the petition and the file. And the college authorities of MP College Dibrugarh to place their respective cases. Proceed that may be done. Let them come again. Principal respondent number 6 is not a party.
No, you say respondent number 6 is not before this court.
Not before.
How can we direct her?
No. He
He's already selected, lord. He's a
No,
she's
but
made a party.
but why direct hear her at this stage?
Because
he is not before this court now.
Our name is forwarded. So our name is
No, where is that recommendation?
No, it was not recommended. Now, as far as my friend says, it has been recommended. The paragraph is the speaking order.
Yeah.
May the penalty may correct up from whereas.
Yeah.
Whereas this director has not yet received any proposal from Kohi College in connection with the appointment to the post of assistant professor department of political science to Kohi College. Then, hence, in view of the above fact and circumstances, the matter is in immature state. The grievances of the video district will be considered once the proposal is received from the concerned college. So, it is considered that it has been sent.
Lordship, this order was passed on 16/8/2025 in the month of August, Lordship. Thereafter, in the last week of October, Lordship, the president was appointed, the GP president, governing body president was appointed. Thereafter, they took a resolution on 31/10/2025, Lordship. And it was forwarded to the respondent number 2, Lordship.
So the recommendation of the selection committee is not reported for.
No, I have been telephonically informed by the respondent number 4, Lordship. That is, Lordship. That's what, Lordship. I have tried to go. I went there yesterday also, Lordship. I could not get a copy of the recommendation, Lordship. They are not giving it, Lordship. Neither the department is giving, respondent number 2 is giving, neither the respondent number 4 is giving it to me, Lordship. In fact, Lordship, I think RTI was also filed, it was also not answered, Lordship. That is why I am before your Lordship. At least they can bring a instruction, Lordship, on the next date. Till next date, no final order.
Unless you convince this court that the name of respondent number 6 is recommended by the selection committee. You obtain
Let him obtain instruction, Lordship. He is be better, Lordship, from the department, Lordship. Whether such an recommendation has been forwarded or not.
even if the name of the respondent number 6 is recommended by the selection committee, we have to see the marking pattern.
Yes.
Even by the selection committee.
That is what I am submitting, Lordship. The marking pattern has to be as per the OM, Lordship. Now, as per the OM, if I calculate the marks, it will come to 65.5, Lordship. That is what, because I have annexed an application form of the respondent number 6. No, Lordship, in the application form, she has given the marks, her educational qualification. Like marks for postgraduate, if it is above 90%, one gets 27 marks, Lordship. This is as per the OM. So I have calculated as per the OM, Lordship. If there is any mistake, Lordship, cost may be given upon. I'm sorry, if there is any mistake in my calculation, or if I am misleading the court, Lordship, the court may impose cost.
I'm not saying that you are misleading the court, but some contextual material there must be.
Then, Lordship,
in order or not.
I am agreeable to him to the extent that if a direction is passed by your Lordship to the director, that at least before selecting, all the candidates should be checked. Then I am agreeable. If such a direction is passed by your Lordship,
Direction can be passed when
yes,
this court commits that the name of respondent number 6 is recommended by the selection.
well, let me take instruction, Lordship, because I am unable to, because neither the principal is, the respondent number 4 is giving me anything, neither the department is giving me, Lordship. That is why my hands are tied.
Whether we have filed an RTI application.
So far, my instruction, because I think my has filed an RTI. Lordship.
When?
To take that instruction, Lordship.
Where is the
First,
copy?
he is right now in. I have to take the instruction.
Order dated 12/11. Therefore, setting aside and causing the new property, causing property with it, but then it recommend the name of the stick for what kind of scope. Assistant professor in science vehicle and also direct the respondent number for whether mandatory not prescribed by the government by office number one one three and comment the grievance of the address in this so the grievance of the business is that pursuant to an advertisement issued by the Kofi College Nogam for filling up a post of the professor of science certificate reserved for OBC and candidate. The petitioner responded by filing by submitting an application and also appeared in the interview on 7/10/2024. Thereafter, he was informed by the selection committee that he had not been awarded mark for his BA General Degree and SSL exam. And thereafter, he filed a complaint with notice that the respondent number hearing who passed take 5, wherein it is confirmed that the petitioner both marks, those marks, and if the said marks are complete, then the total mark of the petitioner would come to 70 points. However, the current of the voted by the user is stated by the who had 65 by the negative topic by process by filing the present as Wilder learned that no referring by by the director on 16/2025 said this repetition effective at this date that when the name the decision number 6 is recommended by the governing body, then so the director will examine the same and only thereafter he will accord approval to the same. However, taking into the submission of both parties, it is provided that Mr. Wilder had some complaint instruction regarding the selection process and that's the code for Wednesday. Right. Yeah, not when.
Hello, My lord, on the last occasion, they made a submission before the court that the selection process has been
Cancelled.
cancelled. Now they were supposed to file. They were supposed to file instructions. But what is the government body of that? Then after that, government body will forward it to that. Or so they have communicated the but so then instruction but forward with
What is your instruction?
pardon, my lord?
What is your instruction?
No, my lord, I don't have any because they have not intimated anything to. In fact, I was not even issued call letter because of which I have filed this writ petition.
That's all right. But whether your
So I know, my lord, that on
interview was conducted on that
no,
day or
the interview was not conducted on the last occasion. That much I know. But whether it is completely cancelled or it will be on a future date, my lord, that instruction, my lord, probably.
so you were sure that on that day interview was
That
not
the
conducted.
interview, that the interview. That was
Okay, you obtain a written instruction.
we have communicated with the 14 point.
So when can we expect it?
Hello, can it be on 25th? 21st, I'll be out of station. 25th.
25th.
Fifth.
Okay. Third Mr. MD sir, third Mr. Govinder, third Mr. Higher Department. Mr. Govinder submits that the instruction are awaited and does the matter in the next. Accordingly, it submitted that this submits the matter on 25th.
What?
First, Mr. Govinder written as the
I'm deeply obliged.
Timing item. Item number 4.
May it pleases your lordship. Lordship, petitioner is a person with disability, having 80% disability, lordship. He has applied for the admission procedure in the PhD program, lordship, and wherein as per the Act, lordship, Rights of Persons with Disability Act of 2016, lordship, there has been in the higher education at least 5% reservation for persons with disability, lordship. So he is one of the candidates for that, wherein he was not selected. So he is aggrieved and he is before lordship.
At page 27, the number of seats for 18 the petition for page 27, serial number 4. Total number of is 7. However, my lord, this is subject to changes the number of sites and all. My lord, total number of candidates selected were 8. Lord, what is to the select list for estimates, my lord, estimates page 61, my lord. Page 61, down below the last table of the page. Total seats advertised 7. Doctor may turn to the next page. The asterisk mark just below the table at the top, my lord. We can answer due to something. My lord, there is a 5% reservation for persons with disabilities. Yes, my lord, as per the rights of the Act. However, my lord, the number of 8, it comes to 0.4. So therefore, we could not reserve it. And this reservation, my lord, is subject. It is not the entire, right? as has been verified. It is the Supreme Court found out upon the taking of the unit as the entire institute in respect of these are service matters, of course, but the same logic applies. It is to be subject because the person applying for physics, he cannot be accommodated in that. But vice versa, it has to be subject. This is the matter. A full bench decision of the Allahabad High Court has been affirmed in these. Therefore, my lord, it's subject wise. Since there is 8 seats, my lord, 5% comes to 4. They have already given a report, my lord, at page 73. This is the report submitted to the Commissioner of Personnel, page 73. On still number 5, the petitioner Mamrez Ali happened to be an applicant for admission into PhD program for 2025 session in the Department of Application. The number of vacancies in the said department stands at 8. Thus, 5% reservation for the reported vacancies in PWD category is coming out to 0.4, which is even less than 1. Once as the reservation in the said category. That is it. Otherwise, my lord, across other my lord, we have made the bit, and I have taken it for the my lord, undergraduate and post. In fact, there were less number of, so all the seats are for especially they are not, they have not been in the other graduate, but PhD is specialized.
Lordship, let them file their reply, then I'll file my counter. But that cannot be PhD overall. Then in most of the subject, they won't get a chance. Then in the higher education, as per the act, minimum 5%, that is the violation of that act, Lordship.
No, if the 5% is below less than 1 seat, then how they would
Lordship, altogether 92 seats, Lordship. 92
whether-
seats in the
whether
PhD.
seats should be considered.
92
If
seats,
it
Lordship.
is counted department by 10,
This is the reason, let them file their affidavit in opposition. I will file my reply rejoinder to that, Lordship.
1 seat is there in the physics department, how it can be allotted to the Assam
That cannot be, Lordship, but it's over the higher education PhD overall is, and as per their report also, 2.117% they have given. 2.117, then how many persons? They, in their report only, Lordship, page 73, they have, of which 2.17% of the candidates belonging to PWD category who got selected on the basis of the conformity of specialization between vacancies. So 2.17 means how many candidates are recruited, Lordship? Means provided seats under this PWD Act.
Let's not be so hard. Yes. Okay. Oh, denied admission of it for the year 5 or suppose such that the number of vacancies in the state department was 8, then 5% reservation, 5% the vacancy. Get it. Then that's why there is perfect. Then I higher tonnage than though in the advertised post seven up to one more book. It is the number eight, 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 and if the 5% reservation complete, then same keep a 2.4 less than 1 seat. That's the result for the PWD category. You treated as a that obviously uh, obviously 80 one. Anybody agree for respondent number one? One over altered but extra set for the after for the time responsibility that by their availability.
Lordship, I move it as legal aid counsel, Lord.
Legal?
Yes, legal aid counsel. Deeply.
Deeply. Timing item 6.
May I please, Your Lordship? Lordship, my son, minor son, I admitted him to a HSLC plus integrated NEET course. I submitted the whole amount, my lordship. Thereafter, before admission,
But you tell me whether this school is a private school.
my lordship, my lord,
Nothing to do with it.
my lord, my lord,
It
it has been already said.
maintained
My lord, let me complete my submission.
is not a full
Let me complete my submission. My lordship, it is regulated by all the laws of the our that is laws of my state is regulated by affiliated to board also and a bill particularly Assam Institute of Assam Coaching Assam Private Coaching and Educational Institution regulation of fee and Assam Admission and Refund Bill 2025 that is still pending in the cabinet, my lordship. So government policy is very much clear, my lordship. It is doing a public function, my lordship. It is in the field of education. When I took admission, no refund policy, they did not handed over me any document on the refund policy, my lordship. It is it is also, my lordship, regulated by that is the AS Seva board, my lordship, and other regulation of the state, my. So it comes under the definition of state. It is already there are amples of judgment of the Supreme Court that when a private institution does a public function, my lordship, it comes under the definition of state. Now it is a matter of, my lordship. After filing of this writ petition, I filed this writ petition on my lordship just 10 days ago, my lordship. Suddenly, the remaining amount has been entered into my. So for getting the amount, my lordship, I have to come to honorable. My son is a cancer patient, my lordship. He is suffering from osteosarcoma. B. Barua Hospital of Authority of the B. Barua suggested me that I should not take him to boarding school, my lordship, and he got above 75% mark, my lordship. Just because he got above 75% mark, his local teacher convinced me to get him admitted. Thereafter, on the advice of doctors, I submitted application that before the class commenced and before the hostel they allotted me hostel accommodation, man. So they did not handed over me any policy document, refund policy document, man.
and they withheld the money. And after I filed the case, they returned the money. Now, rest of the thing, discussion, I leave it to the discussion of the Honorable High Court. my
No,
lordship.
you have received the entire amount.
And now, my lordship. Sir, discussion of the Honorable High Court, my lordship, whether Honorable High Court will consider, that is for getting the amount, I have to come to High Court, whether that cost Honorable High Court will give me, that is up to the discussion. my lordship. But this
No, no,
institution comes under the definition of state, my lord.
no, I don't think so.
Judgments, my lordship, I can, if you give, allow me time, I can give judgments, my lordship. There are amples of judgments. Even the government policy is very much clear, my lordship. In the coaching institution amendment,
Anyway,
my
will
lord.
not spend much time.
Yes,
this
Yes,
discussion.
my lord. my lord.
Third, third,
Yes, my lord.
yes, we don't start it. And third,
120.
one, very good. Five, five, four, that is of the that the that that third, that right, that is and that five, that is the amount, right, that is that that is I did so
Highly obliged.
Timing, sir.
May I please elect? It was reinstated in service on my lord 3/3/2023, my lord. There was my lord departmental proceeding was initiated, my lord, pending disposal of the departmental proceeding, my lord. I was reinstated, my lord. There was my lord. I approached before the Honorable High Court, Lord Standing Council, my lord.
so you have not been given the salary for the period 21, 6, 2022, 3, 3, 2023,
Yes, my lord.
right?
Yes.
And your suspension period is also not been regularized.
Not regularized, my
No,
lord.
that does not arise because the department is yet to be completed.
Yes, my lord. Hearing was already taken, my lord. I appeared on my lord 25 25/3/2023, my 25, my lord, and till from 25/3/2025, my lord, I appeared. Till date, no decision has been taken, my lord. I am in the verge of retirement.
Yes, Madam, you obtain interest on that
I will-
since the decision is taken. Why this amount is taken? Or, sir,
HL obtained.
or it was for the and also hard here or hard it was not really hard. I can be at and it was less hundreds of I predicted landing drug part there by total dated 3 and the petition was suspend period. So if it it has not paid, then it has not paid, then later in violation of the 54, then the departmental process also not paid last 3 years. So the final order being agreed the petitioner approach for which
If I am in the verge of retirement, my lord,
If you refer, if you return it, is it take the
obviously what the this the matter by our
in the meantime, my lord, my representation may be disposed of in the meantime, my lord, during pendency of this petition.
the Lord 7925
Yes, lordship, 15/7, my lord. Another 15/7/2025, my lord.
registered whether they have
We will file fresh representation, my lord, if it is not received.
that
uh, uh, on 25 the director elected for regularity of its service provided that pendency of its related with not bar not stand at the bar it's by affected represented by the
department, whether the department
provided it is received by
Most obliged.
Page number 22 is his initial appointment. And thereafter, my lord, his service was extended up to the age of 60 years. And that document is page number 34. In the year 2020, 1st of July 20, page number 34 is that copy, my lord. From 35 is the original copy. Here, my lord, the clause 1, it is mentioned that in the last, my lord, portion, from the date of initial joining, that is 21/6/14, pursuant to the present agreement, till further order or maximum till attaining the age of 60 years. So, and my lord, clause 3, then during the period of the initial contract, the second party will be entitled to continue draw salary and increment as per ROP. So, though his
service as contractual up to 6 years, but as per regular employee, as regular employee, he has been given all the benefits, my lord, regarding here the salary structure is also, my lord, benefits of CPS, etc., being drawn as per existing system and existing salary special so and so. Next, my lord, the paragraph number clause 10, page 36. Clause 10 here also he is entitled clause 10, page 36. He is also entitled for the leave as casual leave, earned leave, maternity leave, child leave, and other entitled to regular discharge, LTC. So, my lord, my contention is that all the benefits of the regular employee is given to such employees. But what happened, my lord? He was during in the year 2019 during the Puja vacation, he was absent for few days, and thereafter during the COVID period, my lord, he was absent due to some health issues, my lord. And for that, my lord, there was an proceeding, my lord, departmental proceeding, and after the proceeding, he has been found uh, uh, guilty of dereliction of duty, insubordination, unauthorized absence, unsatisfactory performance, socially unacceptable behavior, etc., etc. And he was terminated, my lord. Page number 72 was the termination order, 28/8/24. Page number 72, that after inquiry, on the basis of the inquiry report, he has been terminated from service. Page number 72. But the grievance of the petitioner was that though there was an inquiry, but the inquiry conducted behind the back of the petitioner. The persons who have whose statements recorded, my lord, they were not encountered by the petitioner to examine them or to question them of the allegations leveled against him. Then he had referred an appeal before the appellate authority. And the appellate authority also, my lord, page number 86, my lord, did not allow the appeal and rejected the appeal, my lord, on the basis of the finding of the mission director of the SSA mission. So basically, my lord, the challenge is that the inquiry report is behind the back of the inquiry is conducted. My lord, page number 58 is the inquiry report.
You have not participated.
In the inquiry, my lord, it is conducted behind the back, my lord. After inquiry report, my lord, he has been heard, my lord. But during inquiry, my lord, the persons who had deposed against him, my lord, that persons were not, my lord, given a chance to question. He was given to chance of filing the reply to the inquiry report and to the charges, my lord. Yet, my lord, submitted the reply. But the only grievance is that my inquiry is behind the back, my lord. That is, my lord, as part decisions of the court, my lord, to the High Court is not, my lord, admissible. The principle of natural justice, my lord, in such case is violated.
Where is that?
My lord, termination order, page number 72, my page number 72. May I read?
No, no. Final order.
Final order, my final order, my page number 86, 86, 86, my lord. May I read? 86. The last one.
But this order was passed on 6/9/2025.
Yes.
Yes. I am.
This is the subscription of the agreement. Agreement is before. Before relevant put in place, but
Yes.
Dr. Comes paragraph 12.
Paragraph
12.
Yes.
The continuation of engagement of the second participant and may be terminated by correct term. If the performance of the part or the as per provision of or if the second part of insubordination jurisdiction or any other order, the second part is continuation is also satisfactory report on his or her in attending to academic performance in discharge of duty and socially acceptable political, neutral, and other moral and in this case the citizen stopped attending his class from 29 to 10. Accordingly, Lordship is so-called assistant director. If
Whether he participated in that,
but he supplied the party. If Lordship comes,
reply filing does not say the party.
that is what I'm
But
trying.
whether he
that-
was allowed to protect himself.
Yes, that is what I'm trying. If Lordship comes, okay.
Yes.
14. The senior most secretary to the government of Assam with the appellee software for any matter related to the Lordship, he being a contractor, his entire service is executed by the Lordship. No one disciplinary habit to there. That is not directly applicable to his service is regulated by the terms.
Maybe can is the right process merely
So right
merely
right
because of
to-
this
right
agreement.
to protection comes from the provision some. So in case of contractual absence, that is not a
No,
not
sir,
not a violation of natural subject right to protection. That is a different.
in some of the cases, that's that right to protect the person is also a fundamental.
If it is a rule law, if the service of created by it, wherein it is mandatory for the with the
This,
opportunity of
can this agreement be considered as a rule?
yes, in case of contract, on that point, not like many does. If he is a contractor, he is not governed by the government rule law. Let him show one provision law that disciplinary service applies in case of contractor. That is not. In the contrary, lordship, I get in case of say, employees or SSA, they are not government employees, so there is no question of applying directly. That is the law of. So at this stage, whatever right he has under the contract that he has that he has got the benefit of that. As in the appeal provision also that clause 14. So this appeal provision also comes from the contract itself, not from us. page 37.
My lord, my termination is based on the inquiry report, my lord. The simple issue is, my lord. Since the termination is based on inquiry report, my lord, that inquiry should be made as per law, my lord. It is my simple mission. Since the termination, basis of the termination is the inquiry report, my lord. It is mentioned that on the inquiry report, I have been terminated, my lord, from service. And this is a major punishment, my lord. My service was up to the age of 60 years, my lord. It is terminated, my lord. So at least that right I should have been, my lord, allowed, my lord. The major punishment is, my lord, awarded, my lord, the basis of the inquiry report. At this stage, may I pray for a notice, my lord, that my
Or check out it. Assess it.
Four.
And, One, right, five,
And it 4.
four,
Assess.
order. Number assess it. Okay. It, but it, and also order dated 8 outside that whereby the type was and also direct of the other the picture was serving as assistant teacher.
yes. So,
Was like appointed by the director Turbo Shiksha of the by order dated uh, 9 and those at 8 6 Aditya that were present at third time and it served of the age of years. The career further that the uh, school of the of the on account of Puja vacation.
Puja vacation, then later, my lord, COVID and his health issues.
And
COVID pandemic and
to COVID-19 and then also the of health and thereafter then the patient 5 days reply thereafter a disciplinary proceeding thrown up against him. The neck body was conducted behind the back of the bench. When thereafter the body put part of the picture has succeeded. But ultimately, he started for the third. And thereafter, he deferred and appealed before the second judge of the but by order it is by the further success was allowed part of disciplinary procedure and it allowed it then and it behind it the doctor of some department and such found liable paragraphs are I have kind of are covered by the agreement with the government and as such the chief order as such the termination order can also chief order that the six types of public where the subsequent of both the parties ordered with it ethics of for how long for the stigma with the four, five, seven, different color how not eight is additionally the services of the park and perfect is the matter of the right there expert of park is the
My lord, since it is a matter of termination, so the date may be given.
Pardon?
A date may be given by court. A date may be given.
Date.
Date.
Court.
The court is written
9th January.
oblige. I received that list to WhatsApp, get it downloaded. But in that list, I have went through the list.
And the name of the petition, FSC serial number 270, that is there. And this termination order is also that our termination order I could get the printout. This could get the print. In the list I have seen the name of the petition, FSC serial number 270. And the lordship, there is a
I don't know of which year, my lord, it is.
that is the total determination letter lordship. Subject, this is of subject termination, order for termination of service, reference local notice dated 2020. The reply of the so-called notice, it was so-called notice submitted by you by data dated 2020 has been examined. It is found that your reply is not satisfactory. Moreover, your appointment was issued against the non-existent post by irregularly without following departmental norms and procedures during the period of ban on appointment imposed by government. So your service is hereby terminated with immediate effect. Your salary for the period you have worked is being considered for as per order of the honorable. That this the name of the petition FSC serial number 12.
Your lordship permits me, my lord, I'll just make 1 minute submission. If that is of the year 1992, then after that, all these illegal and irregular teachers were considered, and because of the High Court's order, the screening committee was formed in the year 2012. And ultimately, the screening committee gave their list and it was approved by the cabinet in the year 2020. And then only this taking care of everything, my lord, then those persons forming the 3 categories, the one who received salary up to 2007 and passed JVT, they were considered for regularization. In my case, from their own document, my lord, I'll just rely on their own admission, that is affidavit filed on 2/4/2024. That is starts from page 68, I suppose, my lord. Yes, my lord. Page 68, your lordship got it. Got it. My lord, if your lordship comes to page 72, paragraph 10. Yes. My lord, these are the 3 lists were prepared after and it was placed before the cabinet approval. The list number 1, last below, my lord, the teachers who have received salaries up to 2007 and onward and having JBT DLED are included in the list 1. My lord, got it. Last line, list 1. My lord, that is I'm covered by list 1. Now, my lord, let us come to paragraph 11. It is there. It is filed by the secretary, my lord. Paragraph 11, my lord. 11A, my lord, got it. Page 73. Approval was sought for accommodating those teachers who have received salary up to 2007 and have successfully completed junior basic training. Now, my lord, over here, your lordship may noted, my lord, in the site that I received salary up to January 2012, and I passed junior basic training on 26/8/2011. That is prior to the process of screening committee starts, and that is admitted, my lord, in paragraph 12. The answering deponent humbly begs to state that, as reported by the Director Elementary Education Assam by so and so, the petitioner was appointed as teacher in Silapathar LP School, Dhemaji during December 1989 by the then DI of schools against a non-existent post who falls among 752 numbers of terminated teachers under Dhemaji district who were paid salary for 29 months from so and so to so and so. Thereafter, she was transferred from Silapathar to Dibrugarh as per instruction of the then Director Elementary Education Assam by letter dated 2001. That is important. That means the termination was not given effect to, and all these persons were taken for consideration of irregularly teachers under the screening committee. And she received her monthly salary up to January 2012. It is their admission. So what is the criteria, my lord? 2007 and JBT. However, as per government instruction by letter dated so and so 2012 and DE Assam letter dated 6/2/2012, it was instructed to keep on hold the release of salaries to all concerned relating to 752 numbers of terminated teachers under Dhemaji Lakhimpur district, including those who were transferred from these districts to other districts. Accordingly, the release of monthly salary of petitioner has been stopped from month of February 2012. That means from my date of appointment till January 2012, I received my continuous salary. Next para, my lord. Her case was then brought under the ambit of illegal irregular category of tutors/teachers. The petitioner appeared before the screening committee, and the case was screened on 19/4/2014 by the scrutiny committee as per the instruction of the divisional commissioner, Upper Assam Division. But her name was not approved by the screening committee as she did not meet the criteria laid down in cabinet memorandum, and hence she was not offered accommodation. Now, Annexure 1, it is there, my lord, page 76. My lord, page 76. My lord, I'll come to serial number 1. Is a small order, my lord. My lord, serial number 1, that in compliance of the Honorable Court's final order dated 2/3/2010, passed in WPC number so and so, the Education Department placed the matter for regularization of irregular teachers before the cabinet in its meeting held on 26/2/2011. Thereafter, the Education Department proposed to constitution of scrutiny committee to examine the cases of these teachers with a view to examining the selection procedure and nature of appointment, status of post, working status, status of salary, academic qualification, etc. The Director of Elementary Education Assam invited applications from these illegally appointed teachers during 91/2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. In response to the aforesaid advertisements, applications were received from such category of teachers. After conduct of preliminary examination at the directorate level, the Elementary Education Department constituted 5 screening committees headed by the divisional commissioners concerned and principal secretaries of the 6th schedule area and BTC to examine these applications. Then a committee was formed by the government in elementary education to verify these materials. The committee prepared 3 lists based on screening committee reports. Number 1, my lord, the teachers who have received salaries up to 2007 and onward. Yes, my lord.
Uh, you it is a order.
My lord, what I'm saying, to be very honest, my lord, this termination orders, what they say that after show cause, the termination order was given. My lord, in some cases, termination orders were given, but that were interfered by this honorable court. And lots of persons of these categories, they did not receive the termination order. After that, when this entire scenario of the state came up, that is in the from the year 1991 to 2001, then this honorable court passed an order in the year 2010. Then you take all the teachers of these categories, legal, illegally and irregularly appointed, and you screen them out. Then only in the 2012, the screening committees were formed. And it was formed, my lord, in the 5 committees were formed in the 5 zones. Ultimately, those were placed before the, my lord, cabinet. Cabinet
So,
get the
taken 2 steps.
Hmm.
One, your service terminated.
Hmm.
The other is that if fail to complete the required form in the screening of that we understand. But how it
well, number one, in my, I'm not been terminated. Then my, no, what I'm saying, no, let me say, I'll reason it properly. No, what I'm saying,
The list of level 52 teachers along with this termination.
my lord, for argument's sake, I'm terminated. I'm taking my friend's stand, my lord. For argument's sake, I'm terminated in the year 1992. Then I continued in service. They continued my salary. The cutoff mark was till 2007. In my case, it is 2012. The fact remains, all these teachers of from 91, 89 was also taken care of within that range. From 1991 to 2001, all illegal, irregular teachers were considered.
whether that is some of the part
No. Only thing that, my lord, yesterday,
they were referring to that 6 of 2010
yes,
of this court.
yes, that
This
is
part of the record.
this part of their submission, my lord. It,
The document is not part of the report, but it has referred in
It's-
the memorandum of that cabinet.
yes, that is there.
By in terms of that order of the cabinet member court, this screening of
Whether that order will cover that or not.
not because that is
That will cover.
Not.
That will cover.
752 terminated teachers of Devadi district also under this MP.
Yes.
Therefore, it's covered. That's 2010.
Then how
The lot of subsequent that particular judgment was of 2010. Subsequently, again, there were several there are several other judgments of this Honorable Court, and they were directed to include these 752 terminated teachers under that template and screen them.
okay.
Then subsequently, the screening process has been conducted, and accordingly, they appeared before the screening committee also. But here, these teachers were terminated already. Therefore, the very
No. In your affidavit in opposition, you have taken a different.
lot of for a normal cases lottery, there were criteria that they should get salary of 2007 and they should have DBT, junior basic grade. If they fulfill both the criteria, they will be expected as teacher. Accordingly, even from the Devadi
You see, the present petitioner has not only received her salary till 2007, but till 2012.
lost it. That point,
right?
May I clarify that? They received that some of the teachers, they received their salary up to 2012 in terms of this honorable court order, not in a normal process. There was a direction to pay by creating a supernumerary post for some particular period of time. They have been given registration. But
their cases were that was paid because of the court. Let me bring it on record by way of additional affidavit to require for this. But their cases were they were paid salary up to 2012 February in terms of the Supreme Court order. But the case was that they were already charged. So subsequently that appeared and then they went through this screening process.
If the petitioner has the 12052,
Good.
the 152 officers were screened by the screening committee,
Good.
then we will only examine the report of the screening committee as to why the petitioner is not petitioner's case is not considered by the court.
The petitioner's case was
So that this termination order will not happen.
It will not come in.
okay.
It will not happen.
My lord, only one thing, my lord, before my friend, sir, I'll just take, my lord, only 5 minutes. Would your lordship be pleased to come 77? Your lordship will get cleared.
So you have already argued.
Yes, ma'am. No, I'm saying what is the cabinet gave its approval on 7/10/2020. What is the approval? That is the page 77. And how that in one line they say that I'm not covered. That is there, my lord, in page 77. I'm against that, my lord. In 77, they say, as reported, my lord, this first A, my lord. 77A, my lord, got it, my lord, on top. Approval was sought for accommodating those teachers who have received salary up to 2007 and have successfully completed a junior basic training. Now, my lord, B, I'm not required, my lord. The cabinet gave its approval on 7/10/2020. Now, as reported by DE, letter number so and so, Srimati Deepika Dole was appointed as assistant teacher in so and so, Dhemaji during December 89 by D then so and so against a non-existent post who falls among the 752 of terminated teachers under Dhemaji district who were paid salaries for 29 months from December so and so. Thereafter, she was transferred from so and so to so and so Dibrugarh district as per instruction of the then Director Elementary Education by so and so, my lord, 5/2/2001, and she received her monthly salary up to January 2012. Now, I see the last paragraph. Her case was then brought under the ambit of illegal, irregular category of tutors, teachers, and case was screened on. What my lord pointed out to question that whether these terminated persons were within the ambit of the screening committee. Screened on 19/4/2014 by the screening committee as per instruction of the divisional commissioner AUDA. But her name was not approved. Why? I meet every criteria what you said. So the termination part, my lord, no more covers me. But only thing that you screen, you made a cutoff. I fall within the cutoff. You suddenly say you are not covered. How? And my lord, this is the affidavit of the secretary. Neither the secretary can blow hot and cold at the same time, nor my friend who is representing can go above the pleading of the secretary, my lord. That's all, my lord. It's clear case, my lord. My lord, from 89, this lady has got only 4 years to about 4 years left. Till 2012, she continued till 2014. I've shown that document that when she was a headmaster at that point of time when she was asked to give the charge to somebody. 2014, she continued. After that, nothing, my lord.
It's now no longer in service.
No. That I have already told it to my lord in annexure that till 14, she was asked to hand over the charge, my lord.
She is continuing in the same post.
My lord?
She is continuing in the same post.
No. She has been released. 2014, she was asked to hand over the charge to somebody else. And it was like a forceful taking charge, my lord. After that, I was not allowed to sign in the attendance. went for another 6-7 months. That pleased there, but then she was not allowed to take. Her signature was not taken, and now they have decided. It is not that those who continued or not continued. They're saying that these are the persons we are going to take into consideration whose cutoff is till 2007 and cleared JBT. I've shown it from the pleading as well as the my lord document, and I strongly submit before my lord I fall within that category, yet I have not been approved for no reason at all. Only thing, my lord, this lady has got nothing else, waiting for survival, that's all. And I've given a copy of the similarly person teacher, in fact her cousin. That is the reason she didn't want to give the copy earlier. Her cousin who was given the benefit money, exactly same, Jamaji. That order has been already given to my lord on last occasion, and that is in my reply. My lord, only taking into consideration that their affidavit of secretary and my reply, this case can be closed. This lady has got no other alternative.
Yes, Sir Papa. If the student property has screen her certificate, then can it be said that it not come under the base number 1?
Not the yeah. They will lordship and may take a lordship once to the affidavit. What the screening committee will verify. Lordship may kindly conclude what they will verify. What the screening committee will verify. I will take a lordship to paragraph.
Papa,
The status of
I am looking at the one.
Lord.
Will resume at
Lord. The termination letter. Now, may I take your lordship once to my affidavit, paragraph number 6, page number 70. Why they did not come under that list 1?
I don't know.
Lordship, other? No, this is my lordship. My affidavit starts from page number 68. No, list is not complete. I could not take out the entire page. I just took out the relevant portion, page 1, and the relevant page and the last page. I will place it before lordship the entire page once I get the hard copy, lordship. Lordship, on Monday I will place it. Or Tuesday. Lordship. Lordship. Now I want to take my take a lordship to my affidavit. In that case, lordship may take up after some time. Lordship.
Item 13, water matters.
Malad, in this case, also my learned friend is appearing for state. And here is a case, Malad, they took time earlier also, Malad, to actually seek instruction from the department whether they received the Malad consolidated report from the district.
Also, I have my instruction here. The director has already received the consolidated that list from the district elementary education officer, and now for that the relevant district, the district Dhubri, the petitioners, 43 petitioners are there. That receipt consolidated receipt report has been received and has been forwarded to the government also, and I have received the instruction from the government also. They have also received, they acknowledge that, and now they have forwarded it to the Department of Finance for necessary doing the needful, lordship. So these two instructions I have received today, lordship. So things is moving, lordship, here.
Lordship, no issue. My lord.
Lordship.
My lord.
So Lordship may post after 4 weeks, but it will take some time. Lordship. After 4 weeks.
My lord.
7/1/26. Lordship. Lordship.
August. Outline notes.
Item 12.
My lord, I have completed my part. Only thing is that what my friend has said, I got salary up to 2012 because of the court's order, my lord. That is not known to me because I have not filed any case, and it is neither in the pleading. That much only I have to submit.
Lordship. Page number 70, Lordship. The affidavit filed by the respondent number 1, which starts from page number 68. Now 70, Lordship, paragraph number 6. The married Lordship, that the answering deponent humbly begs to state that in compliance to the order dated 2/3/2010 passed by this honorable court in WPC number so and so, the education department placed the matter of regularization of illegal irregular teachers before the cabinet in its meeting held on 26/2/2011. Thereafter, the education department proposed to constitute a screening committee to examine the validity of the appointment of these teachers. Accordingly, while OM dated 15/11/2011, a screening committee was constituted to examine the case of the irregularly appointed teachers so as to take a decision for their regularization and the entitlement of salary or otherwise. This is important. With a view to examine the selection procedure, the nature of appointment, status of the post, working status. Here, in the case of the petitioners, they were already terminated. So, working status, status of salary, academic qualification, etc. The Director of Elementary Education, Assam, invited application from these irregularly appointed teachers during the year 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 to 4/2/2012 in local newspapers. Therefore, the working status here is a vital. And in case of the petitioners, as I have already placed before your lordship, these petitioners of Dhemaji districts, they were terminated. So they were no more in service at that relevant point of time. As a result, they were already terminated. They have been screened. They have been screened. They have been screened. Subsequently, they have been screened. They appeared before the screening committee. As because they were already terminated, lordship, so they did not. Although it has not been elaborately given in my affidavit, lordship, in the affidavit filed by the respondent number 3, here it has been written that, but her name was not approved by page number 74. Her name was not approved approved by the screening committee, as she did not meet the criteria laid down in the cabinet, and hence she was not offered accommodation. This is there. Lordship. Up to 2007, Lordship. And junior basic training, Lordship. But Lordship, that to that point, Lordship, I have to submit that 2000 up to 2012, the salaries were paid to some, not all the teachers, some of the teachers, in terms of the Honorable Court's order by creating a supernumerary post. So that was a one-time measure was given at that relevant point of time because they were subjected to screening. So that salary up to 2012 were given in terms of this Honorable Court order by creating supernumerary posts to some of the teachers, not all the teachers of Dhemaji district. That was my instruction, although it is not given in the affidavit. Otherwise, Lord, in that case, I will place that instruction also, how they were made payment up to 2012. Let me place it before all of us. The reason for making payment up to, because Cabinet Memorandum is rightly says that up to those who receive salary up to 2007 and have junior basic training, they will be accommodated as teacher. And those who received salary up to 2007 and did not have junior basic training, they will be accommodated as tutor. So that is their law. And they apparently received salary up to 2012. But that 2012 salary was paid in terms of this course order. But in the meantime, their service was already terminated. Loss. So lots of they were also skilled. They were also skilled. In that case, let me place it before lawsuit that reason for that salary paid up to 2012. Lawsuit will fix next week. Lawsuit. 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 That in that regard, that lawsuit. Lawsuit. Let me have the instruction. Let me have that particular instruction in this regard. Lawsuit may fix next.
My lord, only one thing.
Lawsuit.
My lord, only one.
Next.
My lord, only one thing, my lord.
Next Thursday, lordship.
If your lordship permits, my lord. My lord, the matter is heard on 3 occasions. It is part heard. What they have said in their pleading, I made my argument from their pleading only, from that affidavit only. Now, my lord, he can't improve the case now saying something else, my lord. No, he's trying to improve, my lord. Everything cannot be a gospel truth.
No, I'm not improving. I'm just lawsuit. Yes. Lawsuit. Okay.
My lord, then your
Thursday.
lordship, then your lordship will be, my lord, pleased to make it, my lord, mention it. What my friend is said that till 2012 I got because of certain court's order. That order has to be placed.
That instruction will.
No, not instruction, that order. He repeatedly said before this honorable court.
In some of the
I don't know about my case. I am the petitioner. I don't know that I have filed any case. He is saying before this honorable court, because of certain court orders, I have been given the salary up to 2012.
Yes. Order, yes, it is there. Loss.
No. My lord, that is not there in the affidavit.
No, it is there.
No, absolutely not. Otherwise, my lord, in the office memorandum also there could have said, if beyond 2007 anybody got because of the court's order, that will not be considered. That is not there in the memorandum, my lord. And from their affidavit, which I said as Annexure 1,
it is the letter issued only in respect of me, not a general letter. This Annexure 76. Annexure 76, it was exclusively for me. Annexure 1, page 76, that is their affidavit. My lord, got the page 76, my lord. Yes, no, what I'm saying, this is the legal, see the subject, it is only for me. Over there, they have admitted. They did not say anything about the court's order and I got the salary because of the court's order. This is in respect of so-and-so case, Deepika Dole. This is the case.
Lordship, I'm just taking a lordship, which is here. Unsigned
He might be saying about page 74. 74, that is. Yes, my lord. My lord, during the break, I've checked it 4 times. How he's saying that because of the court's order, I got the salary up to 2012. I checked it 4 times, their affidavit, including both the documents what annexed in that affidavit. I did not find anywhere, my lord. Yes, but that letter was in respect of my case.
No, this is one of the cases of 752 teachers. So
that's what I'm saying.
obviously this instruction.
That's what I said. This is in respect of me. They have annexed. But over there, nothing is mentioned that I got the salary up to 2012 because of a court's order. And this is not even in the secretary. The secretary of the department has filed the affidavit. It is not there in the pleading. I've checked it 4 times. Because even I was surprised when before the
Lots.
he made the submission beyond the pleading, my lord. I'm absolutely sure.
No. In some of the cases, supernumerary posts were created, I have submitted, and by the, in terms of this honorable court's orders, that I have submitted also. Let me go there. So subsequently, this. Lordship, I will have Thursday, Lordship.
January 2012.
Lordship. Lordship.
My lord, another thing, my lord, if my lord doesn't take it otherwise, then he persistently said my 2012 salary because of the order. That order should be, my lord, placed before the court.
I am obtaining the instruction.
Yes, my lord. I understand, my lord.
On 19th November.
My lord, that regarding JBT salary, JBT training in 2011, that is important. Okay.
Item 14, order basis.
Deeply obliged, my lord.
May I please your lordship, my lord? My lord, on last occasion, my lord, the SSA, my lord, was directed to produce the report as to why the, my lord, the impugned order was passed, saying that there was no enrollment in the school pertaining to the year 2016 and 17, my lord, in my school. As such, my services could not be provincial as well.
You know, on the last occasion, Lordship heard the elementary education's arguments, but Mr. Chaudhary was, as SSA was asked to bring record. He was here only, my lord. Mr. Chaudhary for the SSA.
He was there.
He is present, my lord. I'll, Lordship take it up after some time. He's coming.
Let him come.
He's here. He's here, my lord.
Lordship, as per this letter, as reflected in the impugned order, Lordship, the report that was sent by the SSA is not available with the office. So they have requested the director who passed the impugned order to forward that report either through the SS who asked or through the elementary department council, Lordship. That is reflected in the letter, Lordship.
Report to 9 is doing that.
Not that much. Yes, sir. You have to ask him there, not that. It was something that they said to asking them on one communicate fancy mentioned, but maybe it was
থাকিব পাৰে।
Okay.
Yes.
Submitted by us before the RC Jain from the Lordship. That the Lordship, they have not found it, and that they have, will make an inquiry, Lordship, what report was sent or why it is not available with the SSA. But since considering Lordship direction, the education department must have maintained a file with the report. Lordship, so they have given that letter requesting them to either send it to us to produce before your Lordship or to their education department council. Lordship, from the impugn order, it reflects that there was an report. There was a report. Now with that letter, Lordship, further I can't say, Lordship, but on the basis of the impugn order, there was a report.
Yes.
That they are going to make an inquiry, Lordship.
I'll get in touch with the department later, because I'll get in touch with the department, but otherwise, my lord, regarding the, generally they should be maintaining one with themselves also. For SSA. They should be maintaining one record with themselves also, but I will ask. I'll get, Lordship will have it after some,
My lord.
2 weeks, then I'll get the.
My lord, may I submit one thing, my lord? My lord, since there was a specific direction, my lord, from this honorable court, my lord, to produce the record. It is the SSA authority, my lord, who is the custodian of this record, my lord. If they are unable to find out any record, inquiry, or any report, my lord, meaning thereby, my lord, there is no report, my lord, at all, my lord. Then Lordship will kindly fix a date in the next week, my lord. Next Monday, my lord, if possible, my lord. I'll pray before your Lordship too.
Apart from this report which your Lordship has asked for, the other report which as per the direction of the court, the order inquiry which was made regarding the school, that report is with your Lordship.
That is a different issue, that altogether.
That also is there. I'm sure it will be there. Let me get back, because last time Lordship had directed SSA. Let me get my instruction from our department also. If whatever.
My lord will give a final reminder, my
In the
lord.
next week.
My lord, without giving them further opportunity, my lord, Lordship will give a final reminder. This is my humble prayer before your Lordship. My lord, without giving them any other further chance, my lord, Lordship will kindly fix it, that without any failure, my lord, they will produce the record in the next date, my lord. That much, my lord, I am praying before your Lordship, my lord. Sure.
Elementary.
As you ma'am. 14. 17 number. I don't know.
Lordship, otherwise there is that I have inquired about. Since Lordship was asking, directing for furnishing the particular debt report that has been taken into consideration. But otherwise, Lordship, in the website, NUPA, there is zero announcement.
Since my lord,
Yes, Lordship.
let's
That
see.
I can, that chart downloaded from the website, Lordship, that I can produce it, Lordship. But otherwise, Lordship, that this specific report, that was not available.
But can it be on 19th, my lord? Wednesday, my lord. Because already on many occasions, my lord. Wednesday, my lord. I have a difficulty on Friday, my lord. Let it be on 17th, my lord.
Thursday,
There's some difficulty. All right.
You will search, they have to search on spelling. Number 15.
Oblige.
May I appear, Your Lordship? My lord, let me quickly recap the matter, my lord. In this case, the matter was heard at length on the last occasion, and the only point which was left to be decided was that whether I was continuing in service. And the college authority, they filed an affidavit, although they submitted a certificate that I was continuing service. But in affidavit, they have stated that no, my service was not continuing. To that effect, the court has directed the order may kindly be looked into on 24/10/25, my lord. Having heard the submission of learned counsel at length, perusal of the record of the college is found to be necessary to ascertain as to whether the petitioner was rendering his service in the college during the period from 12/8/2008 till 18/8/2020. To that effect, the college authority were to produce the record. In the meantime, my lord, we have also applied for the copies of the entire record by RTI, and we got it. If they submitted, my lord, let them submit. Otherwise, I have also got the copies of the entire record.
Lordship, I am appealing for the college authority. I have received the attendance register. Lordship, I have already perused. His attendance is there from that particular period. Yes, yes, is there. But how he maintained two schools, that is not. We could not.
In that,
One, he admits that during this period, petitioner also worked in another LP school, That was not informed to the college authorities.
No, that was by information.
And no lien provision is there, because he is not a government employee.
My lord, by informing the college authority, I did some work there, but even then, I was continuing service in the college. And to that period also, my lord, the attendance register speaks that I was doing the duty, my lord. I have got the entire records, my lord, by RTI.
This
my
is the
lord.
original record.
Lordship, may I submit one thing?
May I submit, Lordship? Please.
Lordship may peruse the attendance register from the day or the subsequent months when he joined the school. He said that he is simultaneously maintaining Lordship here also. In the attendance of Lordship may peruse in month of September, October, November, he was present in the school from early morning 9 a.m. to 3:15 or 4 p.m. He has mentioned it in some of the Lordship in some months, and the school in which he has been appointed. He Lordship, that is 100 kilometers away from the college.
It is not known to the department that how he maintained the both simultaneously. Therefore, Lordship, now government has issued a letter that some inquiry would be caused, calling the persons from the college. This is there. And one letter has also been sent to the mission director, who has appointed him on contractual basis in the school. So Lordship, some time will be required.
The provisional.
Lordship, the page is the register, attendance register. One is Lordship, issued to the mission director also. Mission director who has employed in the school, he has also been issued one, so that he also cause inquiry and and register will reveal everything, Lordship. The attendance register.
My lord, may I refer the register, my lord? I've got the list, my lord. The page 5 may kindly be look. Earlier, they were doubting that I was not doing the service. And then accordingly, the record were called for from the college authority. Now the college has produced the records. Now they're saying that how we can doing duty there also. Now they are just creating a doubt to my service, my lord. And my lord, the fact remain, my lord, the provisionalization that, my lord, the notification speaks that I must be rendered 6 years service from on 1/7/17 from the date of joining to the concerned venture must be on 31/12/10. That period I have already covered, my lord. That notification is, my lord. Yes, it is, my lord, rule 4, sub-rule 2. That is, my lord, the rule is with me, my lord. मी किती स्कूल ज्वाइन करेंगे ऐसे हालत पर नेटवर्क पे पड़ी क्या ये पड़ी मजा नहीं 6 years complete course I think 6 6 years to be completed, my lord. 2008. 2008. My lord? 2008. Is 12/8/2008. 2008. And 8 to 17, my lord. Even if it is taken 8 to 17, then, my lord, almost 9 years. And 6 years is the requirement. And my name was shown in the first list, my lord. If I was not in the college, how did the government has given my name in the first list, my lord? And their only grievance was there, you were not doing the service. Only on that, my lord, my name was deleted. Now the college authority says that no, I was there in the service. And in the record, not only my attendance register, your lordship will find many things are there. Even the college authority has sent me for external duty on behalf of the college in the election duty and all these things.
That your lordship will find at page 6. Page 6, 7, 8, 9, all these are my duties in election and all were there. I represented the college. Page 6 of my document, my lord, which I have given just now. External elevator against the school. That is one thing. Then 7 is, my lord, the college.
It is about 100 kilometers. Yes, lordship. If lordship peruse the register, that will clarify everything. And lordship, even if lordship, he is working also. In some of the pages, he has not mentioned, in some of the months, he has not mentioned the lordship time also. In maximum, he has used. But it shows that subsequently he used to prove and some in connivance with the college authority may be there. So we are contemplating to hold the inquiry, lordship. So that may be allowed. At least 3 weeks time may be given. We will come with the inquiry report. If lordship is satisfied that he was working. Otherwise, also in 2 institutions, how can the 2 service is not allowed to work together? A person is not allowed to work in 2 service together. That is also there, but that will come later on, lordship. Now I am on the issue that lordship. Venture and question of lien in venture code is that does not arise. He's saying he has shown one next one document that he has lordship. Lordship. Then also lordship that one other was of government job, lordship, that school one. If one is doing one government job, then he cannot do the other lordship. That is other way around.
That is, my lord, my option. I can give the honorary service. And my lord, they are doing such a strict rules for me, my lord, but they themselves, they have engaged such a person who was not in the service, my lord.
That also I have discussed, lordship. We are causing inquiry. So, lordship, we are asking for only 3 weeks time. That inquiry should be. We will cause the inquiry. Inquiry report will be there. So that will clarify everything. Just saying that he is present, or I am saying that he was not present, that will not, lordship. That inquiry will clarify everything. Otherwise, we don't have any objection. Anyone may, lordship, who is eligible, he will be entitled. There is nothing personal grievance with against the petitioner with the department. So inquiry will clear everything. He is present throughout the day in the college, and he is working in the school also, drawing the salary. So all the persons from the college should also, lordship, come out, lordship, who has done the mistake.
My lord, the Pankaj Gogoi, his name was also shown in the first list.
Yes.
And he was also doing service, and he resigned from the service in 2021.
And this is the provisional list. My senior is talking about.
He was given, my lord.
My senior is talking about, lordship, the provisional list. He has announced the provisional list in the final list. Therefore, we did the verification in the final list. We found that. And regarding the annexer, that my senior is saying that one Pankaj Gogoi, we will cause inquiry against him also, lordship. How his case has been missed from our lordship.
He is doing service. He has been given the appointment.
So, lordship, this sort of things should be inquired properly, lordship. This is required. Because eligible candidate, we have no objection. If he is entitled, if he is eligible, lordship, we are ready to give. But truth should come out, lordship.
My lord, they are taking just one plea and other. Earlier, they were saying that I was not doing duty service in the college. Now, when the college has come forward and now they have produced the records.
Yes, record.
Now they are saying that how you can do the duty in the school and the college and all these things. My lord, in school I got a fixed honorarium and for fixed period. In the meantime, that college authority told me that they require the economic teacher. So you please do the duty here also. I doing the duty honorary in the college and I continuing the service. My lord, in school, my lord, I am not doing that. School, my lord, I am not giving my service regularly, my lord. Although I was given the appointment for a fixed period, 11 months, but I was not doing that. But in college, I was doing. What sort of inquiry, my lord, they will do, my lord?
So we have sent another letter to the mission director also, so I have placed there. He will also place the, how he was there in the school, both will be in the school. Yeah, so our, basically we'll call all the persons involved in the college, that's it. So that will verify that.
Yes, my lord. Yes. Yes. But then they want to say that the school authority are doing some false, the register, all these things, my lord. They are doubting the school authority, my lord.
Not school authority, college.
Yes, college authority. College authority, my lord.
Three weeks will be lordship sufficient, I suppose. Lordship may 2 weeks or lordship give 3 weeks, we'll try to do it in 3 weeks. Otherwise 3 weeks as
My lord,
directed- as
already the
directed
matter
by
is
the
delayed,
department.
my lord.
Okay,
1.5 year, 1.5 year already been passed, my lord.
So 3 weeks, I think, will not
They
matter.
they did not submit even the affidavit. They were taking time after time.
Affidavit is there, our affidavit is
On
there.
the last occasion, when the lordship has passed that strict order, then only they have submitted the affidavit, my lord.
পূর্বাঞ্চল বলতে পারিস।
Register may be required in inquiry.
Yes, that may be required in the inquiry.
May be required. If the inquiry is.
Yes, that will be required because time is reflected there. Yes. Oblige that.
Original to the law. Time to immediately. Then the crew it will everything. Ah. Petitioner have filed the reasoning that against our affidavit in opposition, but it is not in record probably.
Let it be Tuesday, my lord, fixed Tuesday. Today I have filed, my lord.
Or today.
Friday, my lord. Next Friday, 19th. My lord, they have received.
I don't know.
Also on Monday, also 24th. 24th. Number 17.
May I please your lordship? Also 17 also mine. I have lost the file, have to reconstruct, my lord. I don't know, which Friday, my lord. It's a old pending matter.
My lord, the affidavit of the department has been filed, well.
My lord, affidavit.
We have filed an affidavit. We have filed it, my lord, in the year 23 itself.
We have filed reply.
And they have given a reply. It can be heard on that day.
Deeply obliged, my lord. Deeply obliged. My lord.
May I please, your lordship? My lord, an impugn order is under challenge, my lord. My lord, what has happened, the present institution is a Waqaf, my lord, is established in a Waqaf property, my lord. Now, my lordship is well aware, my lord, that the recent judgment of the Honorable Apex Court has been delivered regarding the Waqaf, my lord, in the Pan India, wherein, my lord, it had been held that the Waqaf property cannot be alienated or, my lord, it cannot be converted into for the any other purposes, my lord. Now, my lord, though that judgment I have not brought in, my lord, but the law is even well settled before the judgment also, my lord. Just for a moment, my lord, I beg to draw my lordship's kind attention to the Jamabandi, which demonstrate, my lord, that this is a Waqaf property, my lord, is at page, my lord, 31, my lord, 31, my lord. I don't know. This is the type, my lord, but the original one is very, my lord, not very legible, my lord. It is very difficult, but even then we have tried to type it out, the relevant part, my lord. If, my lord, peruse this, my lord, due to the Waqaf, the person at serial number 6, that is the Motowali of the Boalipar Madrasa have land measuring 2 bighas in Dag number so and so, along with the person at serial number 2, my lord. So, my lord, there is no dispute that, my lord, this land, the Dag number and the description made in this, my lord, Jamabandi copy demonstrate that this is an Waqaf property. Now, my lord, what has happened? This Waqaf property, my lord, had been given for the purpose of the, my lord, charitable and the religious purpose for the, my lord, person dealing with the Islamic faith for construction of a madrasa. That is, my lord, namely was Boalipar Nizamia Alia Madrasa, my lord. This was a purely a private institution, my lord, only deals with Islamic theological subjects, my lord. So therefore, my lord, what has happened during the course, my lord, what has happened in the land of the petitioners, my lord, another, my lord, institution in the higher category, wherein, my lord, this madrasa education system was, my lord, existing prior to 2020, another senior madrasa was allowed to be, my lord, established, and the land of these madrasas had been, my lord, given to that senior madrasa just verbally, my lord, but there is no any documentation was there, but they were operating from that these private institutions, this Waqaf land, my lord. Now, my lord, later on, the government has converted all the madrasa, my lord. My lord, yes, my lord, my learned friend is here, my lord. Sharma. They have filed affidavit, my lord, and we have also filed the counter also, my lord.
Madam, we have not filed our affidavit yet.
Oh, then who filed?
Yes, it is filed by the Chief Executive Officer, Board of Waqf.
Oh, my lord, I am sorry, my lord. The affidavit has been filed by the CEO of Waqaf, my lord, Waqaf board, but the state respondent has not filed any affidavit, my lord. And the impugn order which we are challenging, my lord, admittedly issued by the secondary education department, my lord. My lord, what has happened? They are now, once they have taken up the land, now they want to take up the movable and immovable property of this private institution, my lord. That is under challenge, my lord. And this privately run madrasa is also been prohibited from operating and functioning, saying that as the, my lord, institution has already been taken up by the government, you do not have any authority to manage the affairs, my lord. Absolutely in violation of the constitutional scheme, my lord. My lord can fix it on any date of hearing, my lord. It will take some time, my lord. My lord, that my lord, what is my respectful submission, my lord, is that those, my lord, madrasas has been provincialized under the two different institutes, my lord, had already been taken up by the government long back, my lord. But this Boalipar Nizamia Alia Madrasa, since its inception, my lord, is a private madrasa. It has never been taken up. Only the portion of the land of this institution was allowed to be used by the madrasa which has already been taken up by the government. Now, while taking up the, my lord, madrasa, now they wanted to take the entire land as well as the movable and immovable structure of this privately run madrasas, and government is also restricting that this private madrasa should also not function, my lord, which is, my lord, is purely arbitrary, unconstitutional and unreasonable, my lord, which I can satisfy my lords with various judgments of the apex court, my lord.
Deputy Commissioner.
High school. Where do you come from?
Of the high school.
No, ultimately to low. No.
Lordship,
See
short of
technical-
the brief, your lordship.
Brief nine.
Brief nine.
It is functioning one way, no?
Historic mailing আছিল ষ্টৰীৰ পৰা চিনিয়ৰ মাদ্ৰাছাখন চলি আছিলে এটা পৰা ইনজামীয়া মাদ্ৰাছা চলি আছিলে তাতে লক লগাই দিছিল আৰু কিছুমান ডাউন ফ্ল'ৰটো আছিলে লক লগাই দিছিল
Extra copy দিয়া হৈছে আকৌ দিম
Lordship may fix a date, your lordship. I'll take the necessary copies from my senior and will obtain the instruction, and if required, we'll file the affidavit too.
Yes, my lord, at page 57, my lord. My lord, if my lord may be pleased to find clause 9, my lord. The movable, immovable property, documents, records of the amalgamated school shall be vested in the name of base new school. My lord, what has happened? After the taking up of these madrasas, my lord, government has come up with another scheme of amalgamation. Now, this madrasa institution has been amalgamated with a high school, my lord. Now, although, my lord, there is no institution is functioning, my lord, but they are now going, my lord, proposal has been made to take up the building, the furniture, this clause 9, my lord, as well as restraining this private institution from operating, my lord, which they cannot. My lord, the government part, we do not have any objection, my lord. The government institution or if any government property is there, my lord, it is their property. But the land wherein, my lord, that original senior madrasa was allowed to function, my lord, till date, it has not alienated or transferred into the name of this, my lord, senior madrasa, and which has been subsequently amalgamated. So still this property is a Waqf property in the name of, my lord, Nizami Aliyah Madrasa, my lord. So therefore, my lord, my respectful submission before my lord is that, my lord, as this is a purely a constitutional issue, my lord, that this Article 25 and 26 is protecting us, my lord. My lord. My lord. Yes, yes, my lord. Government has taken up. My lord, I'm clarifying before my lordship, my lord. There are two categories, my lordship knows, there are two categories of institution in the state of Assam, my lord. One is provincialized and government-run madrasas, my lord. Those has been taken up, and some madrasas are still operating and functioning. Those are purely private and religious, my lord. In every mosque, there is a madrasa, my lord, privately run madrasa. And this Boalipar Nizami Aliyah Madrasa is also has no nexus with the government. It has never been taken up by the government, my lord. Since inception, it is running in its own, my lord. That's why, my lord, we are protected by Article 29 and 30 also, my lord. Status report to যদি আনে next state মানে আমার মাদ্রাসাতে ফাংশন করে আছে না allow. My lord, the chief executive officer affidavit has been filed, my lord, by D. Bora Niki. My lord, this MD Bora was appearing, my lord. Affidavit has been filed by Mayuri Datta Bora, my lord, MD Bora. She's the counsel. On any hearing day, my lord.
Extra copies may be first furnished to us so that.
Already we have served, my lord, first set of extra copies. Now we are going to serve the second set of extra copies, my lord. Already served, my lord. এইবিলাক acceptance of notice বিলাক কাৰ হয় ইয়াত? শৰ্মা, my lord, may I pray, my lord, on the next date, if my respected friends can bring on instruction, my lord, status that whether our madrasas has been allowed to function or not, my lord, that will clarify, my lord. The Dowry can, or the secondary education will be the best person, my lord. দুটা সেট দিব পাৰিব যিমান লাগে দিয়ক শৰ্মা। Whether this Nizamiya, Boalipar Nizamiya Aliyah Madrasa is been allowed to function or not, my lord. My lord, they are not allowing, my lord. So, my lord, may I pray on the next date, my lord, if they cannot file the affidavit or hearing cannot, because the my lord, entire education is suffering and students are also suffering, my lord. An interim order is, my lord, highly required, my lord.
Lordship, if two sets are furnished to us by tomorrow, your lordship, if it is ensured, then we'll do the net full program.
Lord, we'll serve, my lord. Copies will serve.
Two sets by tomorrow.
My lord.
আজিয়ে কৰিম।
হ'ব। Obliged, my lord, highly obliged. my lord.
Matter number 20.
My lord, in this case also, my lord, affidavit has not yet been filed, my lord. Affidavit is required, my lord. We are challenging an speaking order, my lord, in this petition. My lord, this is from the education elementary, my lord.
Lordship, kindly allow me 2 weeks time to file my affidavit, Lordship.
Earlier time was given, my lord.
Second time, third time I said. Third time I said.
Third time I said.
Oh.
अब दोबारा मन लगे
और तो टाइम लगे ना वहाँ पे
कॉपी दिसो किंतु दे मैंने
कॉपी तो ना कॉपी खाना लगा ना
मालूम yes
no Lordship I think no I have to say Lordship I have to check it Lordship because already we sent it from mail Lordship no Lordship already we have sent from mail Lordship
Item
obliged, my lord.
21.
In this case, my lord, on the last occasion, lordship directed the respondents, my lord, to complete the entire process. What happened, my lord, the third MSCP was granted in favor of the petitioner. The benefit was not given till today. And
Lordship, we received a necessary correspondence from the DEO yesterday, and yesterday only it was done, Your Lordship. I'm furnishing a copy of it to the my senior officer.
কুঞ্জলতা দেবী দেখা
Listen, read next, that will also say. Calculation sheet to us. Will rather than become a news.
Oh, we are closing the petition.
Well, in view of this, my lord, lordship may close the petition.
Heard, Mr. I.A. Soikia, learned counsel for the petitioner. And Mr. You are for AZ.
I am correct.
Is that? R. Boro. Learned counsel for the respondent number 5, Mr. Terry for respondent number
I'm for
6.
yes, Your Lordship, 6.
Respondent number 6. And Ms. Pukon for respondent number
Yes, for 1, 2, 3. 1, 2, 3.
respondent number 1, 2, 3.
Finance is there. Sorry,
Mr. Devi, learned standing counsel for the respondent number 6. Today, produce one revised authority dated 30/11/2025 issued by the Directorate of Pension. Before this court submits that the grievance of the petitioner has already been addressed by issuing the revised authority. Mr. Soikia submits that in view of the revised authority issued by the respondent number 6 on 13/11/2025, this petition may be closed. Accordingly, taking note of the submission of learned counsel for both the parties, this petition stands closed. The document produced before the court today shall be marked as Annexure X and be tagged with the
Item 22.
Obliged, one. My lordship. But it is just second round of litigations, my lord. Earlier litigations, my lord, on 22/11/2022, my lord. This court has directed the DLC to place the petitioner's case before the DLC, my lord. Hailakandi. And due to the reasons of my lord, OM dated my lord 18/9/2024, my lord. My case has not been considered till then. That my lord, OM has already been interfered by this honorable court.
Lordship, in this matter, your lordship, since the case of the petitioner was dealt with on the earlier round of petition, writ petition, your lordship. That means 6354/2023, wherein it was directed to place the case application before the next DLC, your lordship. So due to the obstruction of that particular OM, your lordship, 18/9/24, which has been now interfered with. So the earlier direction of the honorable court stands, your lordship, because the issues of that 4 years or that delay has already been dealt with the previous writ petition only. So let the case of the petitioner be placed in the next deals. Lordship, my instruction is there. First para, your lordship. In doing the so, the petitioner may do the necessary compliance of the recent
Notification. No, I have already submitted, my lord. I have complied with notifications.
Okay, then we are closing this petition.
Yes, yes.
Well,
Or Mr. Panipur, learned counsel for the petitioner, and Mr. Devi, learned standing counsel for the respondent.
I'm for respondent number 6, 2 and 6, 1, 2 and 6. your lordship.
1, 2, and 6.
Yes.
And you, madam?
It is for 4 and 5. I
4
I
and
can
5.
represent 3 also.
4 and 5. So I ordered it at 24/9/2025, the respondent authorities were directed to
my lord,
File
22/11/23, my lord. That is page 24.
I am dictating the
My-
order.
Sorry, my, I'm extremely sorry. No, there is 2 orders, madam. I have confused.
I am taking note of the last order.
No, my last order is, madam, there's interpreting of the OM, my lord. That's why I'm, page 20. Oh, my lord, I am sorry, my lord.
I ordered it at 24/9/2025. The respondent authorities were directed to file their affidavit in opposition. But today, Mr. Devi, learned standing counsel for the respondent number. Mr. Devi, here you are for respondent number
1, 2, 3 and 6. your
1,
lordship.
2, 3, and 6 as produced. One report. One letter of the additional district commissioner Hailakandi dated 17/10/2025, and on the basis of the said letter, Mr. Devi submits that since the OM dated 18/9/2024 that's been interfered with by this court. Now, the respondent authority will deal with the case of the petitioner as per in terms of the executive order issued by the personnel department, height number ABP dot 107 stroke 2024 stroke PP stroke 102 dated 30th/8/2025. Mr. Conacher, learned counsel for the petitioner submits that the petitioner in terms of the executive order dated 30th/8/2025 has already applied for the same and also furnished the relevant documents. In that view of the matter, this court is inclined to close this petition by directing the respondent authorities to place the case of the petitioner before the next available deals. The letter furnished before the court today shall be marked as an XRA and will take to the record.
Deep level.
Mr. Conacher, your name is not in the call list.
I'm, the other advocate, has already given my NOC.
But have you filed your color
No,
number?
he has sent me, I'll file different. Well, he has authorized me, but I have not filed today,
You filed your color.
I will file.
Item 23 and
Deep
24.
level. Wait, Mr. Lordship. As per order till 15/9/2025, passed in correction with 5370 Lordship. The first bidder. WPC number.
Order dated?
15/9/2025.
In this both the matter, my lord, we have to file our affidavit, my lord. So sometime is required, my lord.
Lordship, the matter may kindly be expedite, Lordship. A number of other candidates had already been appointed in this case. A short date may kindly be given, Lordship.
Art, Mr.
US Bora.
Learned counsel for the petitioner and
23.
Sharma, learned dissenting counsel for the respondent in secondary education department. Mr. Sorba, learned dissenting counsel for the secondary education department submits that he will be granted some time to file the remedial position. They are allowed to rescission this the after 2 weeks.
Lordship, a date may kindly be after 2 weeks, Lordship.
Okay.
On 3rd December.
Same order in item number 24 also.
Lordship. Obliged.
For bail hearing item 25.
My lord, here I have submission my letter and I am passing for time being my lord. Conducting counsel is my lord, Thakur is the next my lord, in the court number 16.
Who is conducting counsel?
My lord, P. Thakur, my lord.
P. Thakur.
Then my lord, your lordship taken up the next week, my lord, any date, my lord.
But when did you file this application?
Only scan copy received.
Recently. See, there is a direction of Supreme Court to dispose of the bail application within
2 months.
2
My lord.
months.
More than 2 months, my lord. Rejection is more than 2 months, my lord. Yep.
Heard Mr. R. Islam, learned counsel for the petitioner. And Mr. B. Sharma, learned petitional PP for the state respondent. Mr. B. Sharma submits that this matter was assigned to Mr. P. Thakur, who is engaged in some other matters in another court. And he applies for listing the matter after some time. However, learned counsel for the petitioner submits that the matter may be listed in the next week. They are allowed recess unless the matter on.
On 24th.
Nice.
Item number 26 and 27 for orders.
Might be.
So now you are on a different ground.
Yes, my lordship. My lord, the direction of this honorable court was to place the commissioner to place it before the high power committee in terms of the notification dated 13/1/2003. And the secretary has placed it before the high power committee earlier also, my lord, but your lordship, by the order dated 24/9/2025, in the contempt proceeding has again directed to place it before the high power committee in terms of the earlier order, my lord. And accordingly, my lord, 7/11 it was placed, and based on the report that was placed by the Director of Elementary Education before the High Power Committee, the High Power Committee has taken this decision. So this.
No, this court has not directed you to place
Yes,
the
Lord.
matter before the High Court.
Yes.
This
Lord,
court has directed you to comply with the order.
well, 24/9 order, your lordship will carry that. Lordship observed that the decision of the High Power Committee is not in compliance of the direction of this honorable court. As the notification of 2003 was directed to be taken note of. But the decision which has been taken by the High Power Committee earlier, my lord, it appeared to that it was the same decision which was interfered by the courts.
So then we have to proceed with the contempt case.
Yes, lordship. This decision your lordship has seen, my lord.
Seen, but you have come up with a new grounds.
Lordship. But
We proceed with the.
then, my lord, the High Power Committee has to be implemented as a.
No.
Well, because
No.
lordship will kindly
I thought
appreciate.
they were not a party in the writ petition.
My lord will kindly appreciate one.
No.
No, my lord will allow me to
No,
speak.
order is not complied with, then we will proceed with the conduct.
My lord will allow me to submit, my lord, one thing. My lord, the director, the secretary is an authority who can just place before the High Power Committee. And the direction of this honorable court was to place before the High Power Committee, and the High Power Committee needs to be decide. Now, all of the order which I have placed before your lordship is a communication with regard to the decision taken by the High Power Committee.
Lordship, just
Lord, secretary is not the High Power Committee.
Lordship, here in this Lordship High Power.
And the secretary independently cannot.
No, you tell me, where is the provision for implementing the High Power Committee in a contempt case?
My lord,
Under what provision of law?
My lord, under the contempt, my lord, jurisdiction. My lord, the direction before, my lord, it has to be seen, my lord, whether there was a full disobedience or not.
That interpretation is.
Then my lord will allow me to file my affidavit to bring on record this one.
Yes, by Monday you file your affidavit.
By Wednesday, my lord. Let me bring on record, my lord, everything by the secretary. And in fact, my lord, my respectful submission is, my lord, the secretary cannot go beyond what has decided by the High Power Committee.
Okay. If the
And secretary
hyper,
is not the hyper committee.
hyper committee is the appellate authority of this court, we will look into the.
No, my lord,
matter.
I'm
We
not
will
saying,
deal
I'm
with
not
the same.
saying that. The lordship will kindly
We will
appreciate my
deal
words, my
the
lord.
same in accordance with the provision of the.
Let me file my affidavit, my lord, and bring on record, my lord.
By Monday, you file your affidavit.
My lord, Wednesday.
No. Heard Mr. Ihok, learned counsel for the petitioner. Then Mr. B. Kosik, learned counsel for the contempt notes. During the course of deliberation, Mr. Kosik has produced one order dated 14/11/2025, whereby the claim of the petitioner was again rejected. By holding that the petitioner is ineligible for provincialization. Accordingly, it is provided that Mr. B. Kosik, learned counsel for the contempt note, shall file an affidavit bringing on record this order by next Tuesday. This is a list the matter as parted on Tuesday.
Highly applies, lord.
Objection. 28. Lordship, on 24th of October, Lordship, I prayed for. Lordship, the petitioner has been suffering from illness, for
I
want of
am
money.
sorry, actually, this matter is allotted to some other council, my lord, so I cannot follow, this matter take up, so carry forward the matter. So, my lord, I have not received the instruction regarding that, but I have already telephonically contact the officials, and he told me that it is finance approval is required regarding the provincialization. And moreover, my lord, today is Matipiti Bandana, so the clerk, so the officers who dealings with the matter, he is not coming to office, my lord, today. So, my lord, sometime maybe granted so that I can obtain the instruction, my lord.
Okay, by next week.
Yes, my lord, next week.
On the last occasion, Lordship, order has been passed in his presence. In fact, he has prayed for 15 to 20 days time, Lordship, recorded in the order dated 24, Lordship. To complete the process, Lordship. Kindly peruse, Lordship.
Okay, if the person concerned is not available today, let it be in the next week. In the meantime, you will obtain instructions. Heard Mr. R.S. learned counsel for the petitioner. And Mr. U. Sharma, learned serving counsel for the respondent in secondary education of Nepal. Mr. Soliha, you are here?
Yes, Lordship, here I was assisting the court, Lordship. We are not a
Yes.
party.
Lordship, my learned friend, finance department says that there is no requirement of finance department contract.
Lordship, there is
Now-
one. Lordship, there are two head of account, Lordship. Area salary and area wages. Depending on which, if they are paying the petitioner from the area wages, they don't need our concurrence. Now, if from the area wages head of account, if they are making the payment, there are approval be required. And that will all depend from the authorities in the education department from which head of account they are paying. That is why I'm just clarifying.
I can just.
Which my learned friend has said. Yes, so that has to be clarified by the education department. If it is being paid from area wages, then our concurrence will be required. But if the budget is already available with the area salary head of account, then our concurrence is not required. So that instruction also my learned friend can place also from regarding concurrence of the finance department.
So, my lord, as the junior officer is not available today and he is absent.
All right.
Government
No, the junior officer.
Mr. U. Sharma, learned standing counsel for the respondent in secondary education department summit state. Though he was asked to obtain up-to-date instruction, he could not obtain the same as the person concerned is on leave. Then he press for listing the matter in the next week. Where allowed, this is a list the matter on. Okay.
24th.
24.
Item 29.
Obligation.
Maybe special. Just kindly see last order date 4/11/25, my lord.
My lord, exactly similar cases, two other cases were just now listed before code note 50, where they are directed to include the new incumbent. Here, what happened, lordship, the petitioner was already been accommodated at the tutor, where with a condition that he will not claim the past services. So he accepted the term and he has, when the join, he has joined and this is a joining letter. Now, they want to, now, on last occasion, what the honorable court had directed us, the respondent want to file an affidavit. The respondent one was earlier represented by my lord Justice R. Mazumdar. So he is no longer here, lordship, and respondent one retired 4 years back. And respondent two has already been expired. So they let them complete the new incumbent, lordship, so that we can file an affidavit from the new incumbent, because he was already been accommodated.
Okay. You
we'll
will
file-
the new incumbents. Pardon me, sir.
A. Hussain, behalf of J.I. Borbuya.
A. Hussain, learned counsel appearing on behalf of Mr. J.I. Borboya,
Yes.
learned counsel for the petitioner, and Mr. S.M.T. Sesti, learned counsel for the
For the respondents, lordship, may kindly.
respondent.
For the respondents,
For the
lordship,
respondent.
because I missed.
Mr. Sisti has pointed out that the contender number
One,
one,
retired long back, lordship.
one,
Yes.
Sri Pritam Soikia has already retired on superannuation. And respondent contender number two
Expired.
has already suffered demise. Respondent number
Three
three,
and four, I think they are also no longer in their posting, lordship.
3 and 4 are also no longer in their in the said positions. And as such, there is a requirement for including the new incumbent as the respondents or contender in this petition. Accordingly, the learned counsel for the petitioner is directed to include the new incumbents in place of respondent contender number 1, 2, 3, and 4. This is a list of matter after 2 weeks.
4 weeks, my lord.
4 weeks. This is of 2016 matter.
Item
Yes,
30.
my lord.
In this case, I want 1 week time to include new incumbents. Earlier, I took time, my lord, long back, but it is already been prepared, but by next week, I will file including the.
Or Ms. K. Devi, learned counsel for petitioner. Ms. Devi submits that she may be granted some time to include the new incumbents. New incumbents in this petition. Parallel of the official legislator, Dr. Wani.
Highly obliged.
31.
May I please, your lordship? My lord, before going to the fact of the case, my lord, before going to the fact of the case, may I just very briefly, my lord, refer to section 3111 of the 2017 Act, my lord, that provincialization act, my lord. Wherein the matter pertains to, my lord, the provincialization of my lord, services of the teachers, my lord. There is section 3111, my lord. There, as per the section, as per the mandate of section 3111, my lord. There is a-
Whether the instructions are available. Who are appearing for the respondents?
My lord, on earlier occasion, my lord, on earlier occasion, my lord, they have produced some instruction, my lord. District Scrutiny Committee in pursuance to order, my lord, on 8/1/2025. And my lord, after this honorable court, my lord, after going through the, my lord, that instruction and record that has been produced before the honorable court, my lord, some anomalies were found, my lord. The subject of by the petitioner was changes. Therefore, my lord, my lord, this honorable court, my lord, right order dated 8/1/2025, it has been directed to give the instruction to the, my lord, deputy commissioner. He is the, my lord, chairman of the
There
district.
is also one order.
Yes.
13/10/2025.
Yes, yes, my lord, my lord. On my lord, 2/28/5/2025, last opportunity was also given, my lord, to get the instruction regarding that aspect, whether the, my lord, how it was done, my lord. It has been done.
Mr. Devi, you are here?
Yes, your We are representing the Deputy Commissioner, Your Lordship. Lordship, instruction dated 5/7/25, it is here, Your Lordship. That has been communicated to one of my senior friend, Girin G. Pegu, Your Lordship. But that has not been put by affidavit, Your Lordship. So Lordship can peruse the instruction and if Your Lordship instructs me and give me a short date, I shall put the same on affidavit.
Okay,
Here
you
only
leave the same on record so that
Yes.
it may also file his reply
Because
to
it
the
should have been
SSA.
filed. I don't know why it was not so.
long back they have received. My lord, here is, but the issue is very simple, my lord. As part of record, my lord, and as part of order passed, my lord, after verification of the all the my lord, relevant documents, the director, my lord, herself passed an order, my lord, wherein it has been, my lord, stated that I am a social science teacher, my lord. That my lord will file, my lord, on page 32, my lord. Page 32, my lord, there is two tables, my lord. There is second table, my lord. Second table, name of the school, my lord, and name of the teachers. Here, my lord, the Lokinath Sinte. Here, the Lokinath Sinte is the petitioner. On the right column, my lord, subject code, social science. This order has been passed by the director herself, my lord. Now, my lord, in spite of that fact, my lord, as part of section, my lord, mandate of section 3111, my lord, in case of provincialization, it is mandatory to provincialize the, my lord, services of 3 teachers, my lord, at least, my lord, 1 for language, my lord, 1 for social science, and my lord, 1 for mathematics and science. So, as part of mandate of the section 3111, my lord, my service has to be provincialized. Social science, my lord. My lord, after verification of the relevant documents, they, my lord, themselves, my lord, saying that, passing the order that I am a social science teacher, my lord. But in spite of the fact, my service has not been provincialized as on date. My lord. That is the very, that is the, my lord, fact. Very, my lord.
But your name has not been recommended by the district level committee and also by the state level committee.
Yes, my lord. I have, my lord, this is the second round of litigation, my lord. Earlier, the honorable court has directed being, my lord, the social science teacher, I have an statutory right. My lord, I am acquiring a right, and my lord, to file a representation before the, my lord, director of elementary education, my lord. And I have filed a representation. My lord, after the filing the representation, this order was passed. Well, they have to consider my claim. They have to provincialize my same, my lord, my services, being a, my lord, teacher of social science. But instead of, my lord, provincializing my services, after filing the representation in pursuance to the earlier, my lord, order passed by this honorable court, they have, my lord, they are saying that social science, I am a social science teacher, my lord, but my name has not been recorded, my lord.
As per section?
Section, my lord, 3111. This book, my lord, will find on page, my lord, that's page 111, my lord. 111, 111, my lord, page.
111?
111, 111.
Okay.
My lord, section 11, my lord. 3111. My lord, got it?
Yes.
My lord, in case of Bhensar Upper Primary School, in case of Bhensar Upper Primary School, there shall be minimum 3 teachers of tutors, at least 1 teacher each for science and mathematics, B social studies, and C language.
Then how many teachers have been provincialized? Or
Yes, here my 2 teachers has been provincialized. My lord.
2 teachers.
2 teachers. 2 teachers. My lord will find that detail.
Who are they?
My lord, respondent number 6 is there. I am making him my lord, party other because he.
It's a
My lord,
Anando Paeng.
yes, my lord, he is a my lord. Anando Paeng is my lord, Assamese teacher. He is a language teacher. My lord will file a detail on page 23, my lord. Page 23, my lord, that is the pro forma prepared by the Mr. Anando Paeng himself, and that is sent for provincialization of service.
Page number 23.
23, my lord. There is a pro forma, my lord. The subject dot number 1, my lord, Anando Paeng. On the right column, my lord, Assamese. Assamese, my lord. He is language, my lord. Thereafter, my lord, Lokinath Sinte petitioner, my lord, social science. Thereafter, my lord, Nilima Bora, my lord, Sochidhar Borua, science and mathematics. My lord, Sochidhar Borua and Anando Paeng is provincialized, my lord. Social science was left out, my lord. 1 language and 1 social science.
In page number 22, where it is mentioned?
My lord?
Page number 22, where it is mentioned?
23, my lord.
23.
23.
Ononto Paing.
Ananta Pang, Ananta Pang, my lord.
Is Assamese language.
Assamese language, my lord. Thereafter, my lord, petition, Lokinath Chinte petitioner, my lord.
And
Petitioner,
what Nilima Bora is Hindi.
my lord.
Nilima Bora?
Nilima Bola is Hindi, my lord. She is also language. One language, Assamese, my lord, one language has been provincialized, Ananta Pang.
Where is the resolution of the district scrutiny committee?
Well, that resolution was not, the copy is not with me, but that perhaps that was on record, my lord. On the earlier occasion, so far as I remember, my lord, some documents were submitted. Not the resolution, but that the recommendation of 2017 was there, perhaps. In that, my lord, recommendation, my lord, also my name has been inserted as social study, my lord. 2017 prior provincialization. There is a table. My name was there, my lord, as social science teacher in a table, my lord. Along with other teachers.
No, whether district scrutiny committee has recommended your name.
My lord, my name has not been recommended, but my lord, they are sending my name as social science teachers. My lord, what subject I have taught that has been mentioned, but my name was not recommended, my lord.
Why? Mr.
Lordship, yes, your lordship. May I, your lordship? Yeah. Lordship, Lokinath Chinte was appointed as an assistant teacher by the SMC of Tribhuvan Missing on 5/2/1987. At the time of his appointment, his qualification was 10th pass, which does not fulfill the criteria as laid down in the Director Elementary Education letter dated such 28/12/2007 and the government notification dated such 12/12/2000. As per the above government notification dated 12/12/2000, the minimum eligibility criteria for appointment as assistant teacher in upper primary school is graduation. And as per letter dated 28/12/2007, the minimum eligibility criteria for appointment as assistant teacher in upper primary school is HSSLC, both of which were not fulfilled by the applicant during his appointment. The school management committee of the Tribhuvan Missing Janajati school had also violated the above notifications while appointing Sri Lokinath Chinte as assistant teacher of the school at that point of time, your lordship. So due to the lack of qualification, what it speaks so, your lordship. And that headmaster, the headmaster as a graduate teacher, he is entitled to teach the subject, that is social studies, Assamese and English, alternatively for the class 6 to 8, your lordship. They have given it so. So,
now, my lord, may I submit, my lord? But in the proforma, my lord, my lord, that here, my lord, the petitioner is HS, my lord. In the proforma, my lord will find on page 23, petitioner is higher secondary, my lord. Prior provincialization. His, my lord, qualification is higher secondary. And so far as the, my lord, final, my lord, requirement of the qualification BSc in all these, my lord, sections, my lord, qualification is, my lord, concerned. As part of my lord, section 7 of 2017 Provincialization Act. So, just for a moment, section 7, my lord. Section 7, my lord, provides 5 years time to those persons who are not, my lord, fulfilling the requisite qualifications at the time of provincialization. My lord, in file on section 7, my lord, page 116. My lord, section 7, educational and professional qualification of tutors. The tutor must acquire the prescribed educational and professional qualification within a period of 5 years from the date of publication of the order of provincialization of services of the teachers and or tutors of the concerned venture educational institutions in the official gazette so and so. After acquirement of required qualification, they shall be upgraded to the post of teachers in the appropriate cadres. Para 2, if such tutors fail to acquire such prescribed qualification within a period of 5 years, from the date of publication of the order of provincialization in the official gazette, their cases shall not be considered for upgradations to the post of teacher after the lapse of period of 5 years from the date of publication of provincialization order in the official gazette, and they shall continue to function as tutor as per same terms and conditions which were applicable to them before provincialization of concerned venture education institution. My lord, it is very clearly says even if a person fails to acquire the requisite qualification within that 5 years of stipulated period that has been, my lord, as per this, then also he is, my lord, entitled to continue as a tutor. His service shall not be provincialized as a teacher, my lord, but he is entitled to serve as a tutor, my lord. That is the fact. And my lord, more significant, the main here, the fact herein is that, my lord, the DLC is, my lord, taking some resolution, in fact, wherein, my lord, what they are trying to, my lord, what they are doing, it is not a case of only, my lord, in case of a single cadre herein, my lord, there's a number of cases has been filed. What they are trying, my lord, they are ousting the social science teacher. And instead of provincializing social science teacher, they are, my lord, provincializing, my lord, services of 2 language teachers. In many cases, Hindi, Assamese, and like this. And what they are doing, my lord, they are, my lord, formulating a law whereby they are saying the DLC that the headmaster is entitled, headmaster is treated to be a social science teacher. I have gone through the act, my lord, for number of occasions. There is no any single provision whereby it says that, my lord, say headmaster is, my lord, a teacher of social science. It's an irrebuttable presumption of law, my lord. If, my lord, somebody is teaching a teacher of a particular subject, specific subject, he's the, my lord, teacher of that particular subject. How, my lord, being the head of the institution, he can. That is, my lord, that has been specified.
Lordship
And in, my lord, in the 2017 recommendation that has been recommended, therein also, my lord, DLC inserted my name, even though my name has been not recommended, my name is as a social teacher, my lord. And the director herself.
Okay, Sir David.
Lordship, that DLC resolution.
What is the DLC resolution?
Or may.
And I am, my lord, HS passed.
Prostav number 2. Triveni missing Janarazdi ME School, Your Lordship, Director of Elementary Education dated. Lokinath Sinte আবেদনকাৰীয়ে উক্ত বিদ্যালয়ত সমাজ বিদ্যা শিক্ষক হিচাপে নিযুক্তিকৰণ হ'ব লাগে বুলি অভিযোগ কৰিছে। যদিও ত্ৰিবেণী মিচিং জনজাতি ME স্কুল বিদ্যালয় পৰিচালনা সমিতিয়ে জিলা নিৰীক্ষণ সমিতিক দাখিল কৰা বিদ্যালয় তথা তথ্যপাতি পুনৰীক্ষণ কৰা ত্ৰিবেণী মিচিং জনজাতি ME স্কুল বিদ্যালয় পৰিচালনা সমিতিয়ে অনন্ত পায়েং স্নাতক কলা উত্তীৰ্ণ প্ৰধান শিক্ষক হিচাপে নিযুক্তি দিয়া দেখা গ'ল। চৰকাৰী অধিসূচনা ইংৰাজী ডেটেড সাচ এণ্ড সাচ পত্ৰ অনুসৰি সকলোবোৰ কৰি হেতু নিযুক্তি প্ৰদান কৰিছে। যেহেতু উক্ত অধিসূচনা অনুসৰি প্ৰধান শিক্ষকজন স্নাতক হ'ব লাগে, কিন্তু অভিযোগকাৰী শ্ৰী লক্ষীনাথ চিন্তেক শিক্ষাগত অৰ্হতা নিযুক্তিৰ সময়ত ত্ৰিবেণী মিচিং জনজাতি ME স্কুলত বিদ্যালয় পৰিচালনা সমিতিয়ে কেৱল 10ম শ্ৰেণীৰ অধ্যয়নৰত ত্ৰিবেণী মিচিং জনজাতি ME স্কুলৰ অপ্ৰদায়িকৃত বিদ্যালয়খন স্বীকৃতিৰ সময়ত বিদ্যালয় পৰিচালনা সমিতিয়ে এজন প্ৰধান শিক্ষক, 2জন সহকাৰী শিক্ষক, এজন বিজ্ঞান শিক্ষক আৰু এজন হিন্দী শিক্ষকৰ ছাত্ৰ-ছাত্ৰী পাঠদানৰ দিবৰ বাবে নিযুক্তি দিয়া দেখা গ'ল। শ্ৰী লক্ষীনাথ চিন্তেক ত্ৰিবেণী মিচিং জনজাতি ME স্কুলৰ বিদ্যালয় পৰিচালনা সমিতিয়ে দিয়া নিযুক্তি পত্ৰ পুনৰীক্ষণ কৰাত নিযুক্তিৰ সময়ত 5/2/1987 10ম শ্ৰেণীৰ অধ্যয়নৰত পোৱা গ'ল আৰু এজন সহকাৰী শিক্ষক এছিষ্টেণ্ট টিচাৰ হিচাপে নিযুক্তি দিয়া দেখা গ'ল। শ্ৰী লক্ষীনাথ চিন্তে সমাজ বিদ্যাৰ শিক্ষক ছ'চিয়েল ষ্টাডিজ টিচাৰ হিচাপে নিযুক্তি দিয়া নাই। নিযুক্তিৰ সময়ত নিৰ্দিষ্ট প্ৰয়োজনীয় শিক্ষাগত অৰ্হতাৰ প্ৰমাণপত্ৰ পোৱা নগ'ল। লক্ষীনাথ চিন্তে নিযুক্তিৰ সময়ত 5/2/1987 10ম শ্ৰেণীৰ অধ্যয়নৰত সমাজ বিদ্যাৰ শিক্ষক ছ'চিয়েল ষ্টাডিজ টিউটৰ হিচাপে চৰকাৰী অধিসূচনা ইংৰাজী ডেটেড সাচ এণ্ড সাচ আওতাত নপৰাৰ বাবে পুনৰ বিবেচনা কৰিব পৰা নগ'ল। শ্ৰী অনন্ত পায়েং প্ৰধান শিক্ষকজনৰ লগত 2জন সহকাৰী শিক্ষকে 3টা শ্ৰেণীত 6, 7 and 8ৰ বিভিন্ন বিষয়ত সমাজ বিদ্যা, অসমীয়া আৰু ইংৰাজী হাল সলনিকৈ হিন্দী, বিজ্ঞান আৰু অংক বিষয়ৰ বাদে পাঠদান দিবৰ বাবে দায়বদ্ধ। যিহেতু সমাজ বিদ্যা, ছ'চিয়েল ষ্টাডিজ বিষয়ত পাঠদান কৰিবৰ বাবে নিৰ্দিষ্ট প্ৰয়োজনীয় শিক্ষাগত অৰ্হতা বিভাগীয় কোনো নিৰ্দেশনা নাই, গতিকে শ্ৰী অনন্ত পায়েঙৰ স্নাতক আৰু কলা উত্তীৰ্ণ ত্ৰিবেণী মিচিং জনজাতি ME স্কুলত বিদ্যালয়ৰ সমাজ বিদ্যা, ছ'চিয়েল ষ্টাডিজ, ইংৰাজী আৰু অসমীয়া বিষয়ৰ পাঠদানৰ লগত সমাজ বিদ্যা শিক্ষকৰ শিক্ষক social studies tutor হিচাপে চৰকাৰী অধিসূচনা ইংৰাজী dated such and such আউটত পুনৰ বিবেচনা কৰা হ'ল। And thus is this গতিকে আজিৰ সভাই শ্ৰী অনন্ত ফাইঙৰ স্নাতক আৰু কলা উত্তীৰ্ণ ত্ৰিবেণী মিচিং জনজাতি এমই স্কুলৰ social studies tutor লগতে আছামিজ and ইংলিছ বিষয়ৰ পাঠদানৰ হিন্দী বিজ্ঞান আৰু অংক হিন্দী সায়েন্স and maths বিষয়ৰ বাদে তথা অন্যান্য বিষয়ৰ টিউটৰ হিচাপে দ্য আছাম এডুকেশ্যন সাচ এণ্ড সাচ এক্ট 2017 311 দফা অনুসৰি পৰ্যালোচনা কৰি আজিৰ সভাই পুনৰ অনুমোদন জনাবৰ বাবে ঊৰ্ধ্বতম কৰ্তৃপক্ষলৈ প্ৰস্তাৱ প্ৰেৰণ কৰাৰ সিদ্ধান্ত গ্ৰহণ কৰা হয়। This is the resolution.
So much at here.
So, on the date of your appointment on 5/2/1987,
My lord.
you were studying?
No, I'm
in
ACS,
class
my lord.
10.
ACS. Higher secondary.
As per this,
No, my lord, that is not required, my lord, the prior provincializations, my lord, that as per the act, my lord, my lord, prior 2000, my lord, 2010, a person has to, my lord, render continuous, my lord, 6 years of services.
without the requisite qualification.
No, my lord.
Then
Requisite qualification means, my lord, ACS minimum at that moment of time. And I am acquiring, my lord, my ACS, my lord, way back in, my lord, more than, my lord, 12 years back. Even though, my lord, it may be, my lord, because at that moment of time, my lord, there was Bhansar's, my lord, school show there, somebody has to, my lord, call, and my lord, they are allowed to, my lord, to render their services. But as per the requirement, which is, my lord, minimum requirement, that the minimum tenure within which, my lord, I will have to, my lord, acquire the minimum qualification which is, my lord, relevant at that moment of time. I have already, my lord, passed off ACS prior that, my lord. So, my lord, that is irrelevant at the very moment of time, what was my qualification. I am, my lord, fulfilling the testify. That requires that a person has to render minimum 6 years of services, that prior 2010, that I have acquired. I will, if I can file an additional affidavit to substantiate my fact, submitting all my relevant documents herein. And virtually that what they are saying is that that they are, as I have already made my submissions, that that I am not fulfilling the criteria to be, for headmaster, and headmaster is allowed to teach all the subjects, ousting the social study teacher. That is the that resolutions, whatever they have inserted therein. And in the performance itself, it is ACS. And no, I have passed my higher secondary, ACS itself in the performa, which has been prepared by the headmaster himself. And nowhere.
no, their contention is that on the date of appointment, you did not acquire the relevant qualification.
My lord, date of appointment, my lord, is correct. Date of at that day, I have, my lord, appointed in way back in, my lord, in the year 87. At that moment of time may not be. That I may not acquire the qualification, but that is not mandatory. But prior provincialization, 2010, prior 2010, a party has to render minimum 7 years. That within that stipulated 7 years, I am not within that, that the 7 years back.
Okay, you file your additional affidavit,
My lord.
finding on record all your educational qualifications.
My lord. Lord, you may kindly fix the date, my lord, after, my lord, 1 week, any date, my lord. It is in my case.
Yes, so should we keep this with a record or you will take it back?
Lordship, if it is recorded, it will, I'll take a copy of it. Honorable court may retain one of it.
Okay.
Or,
Mr.
Okay,
B.K.
that's-
Das, learned counsel for the petitioner, and Mr. Devi, learned counsel for the respondent number. Learned advocate for the respondent number 2 and 3. Then Ms. Esquo for respondent number.
No.
1, 4.
Who is state level committee?
Five.
1, 2.
Second.
Yes, Lord. 1, 4, and 5.
I'm for
1,
3.
2, 4, and 5. Then Mr. Devi for 3.
Yes, Your Lordship.
During the course of deliberation, Mr. Devi has produced the resolution on the minutes of the meeting of the District Scrutiny Committee. This District Scrutiny Committee indicating the and submits that the case of the petitioner could not be considered by the committee on account of non-fulfillment of the requisite criteria of being appointed as teacher. At this stage, Mr. Ikedas, learned counsel for the petitioner, submits that he may be granted some time to bring on record the educational qualification certificate of the petitioner, where is accordingly allowed to recessal is the matter. After
my lord, can it be on 2020, my lord?
20 of this month.
My lord.
Next week?
Next.
Last week of this November?
Yes, my lord. Last week in November, any date, my lord. 27th. 27th.
The resolution of the state level committee shall be produced resolution of the state level committee shall be marked as Annexure A and will take you the report.
Obliged, Your Lordship.
Obliged.
District level committee.
No, there it is DSC.
DSC, yes, please.
Wait, please, your lordship. Lordship, here it is the order of my lord 18/1/2023. By this order, my lord, the honorable court directed to provincialize service of the petitioner if found eligible and provide all benefits from as given to other teachers, my lord. So that is from 1/1/2021.
Yes, you have filed your affidavit.
My lord, not my lord. I have received the instruction, my lord. The secretary has already sent it to the finance department, the proposal that has been sent by the director, my lord. Now the finance has re-endorsed the file to the secretary, saying to take a view from the judicial department. And it was sent to the judicial department and it is pending in the judicial department since 9/6/2025.
9/6. Miss Bormon is there. DD Bormon.
I think she can also take.
She can.
Listen, David can take.
So, can you obtain instruction on why this matter is pending in the judicial department? Huh?
In fact, the speaking order was passed by the secretary, disposing the statutory appeal, holding him he is eligible for provincialization.
Then,
and for post creation, we have sent it to the finance department. The finance department has returned it back, saying the judicial department views is to be obtained.
And so when the honorable courts had given, when the judicial department is above the honorable court, my lord. Why it is necessary, my lord?
I think if the judicial department is asked for, my lord, if she can take the instruction.
okay, let us say, or let's say in next week. Heard Mr. Khandokar, learned counsel for the petitioner, and Mr. Kosik, learned standing counsel for the contender, counsel for the contender. Mr. Kosik submits that disposing of the statutory appeal by the contender. Is that resolution is that order is part of the record?
My lord, we'll see there is a bunch of paper, my lord, which I have given earlier, my lord. Just after the note sheet, my lord. Order sheet, my lord. There your lordship will find its page number 4, the speaking order.
Everything done, my lord. Only for it was sent for creation of post. No?
Yes.
There it is filled up.
My lord, I think page number 4 is the speaking.
Order.
Order. And pursuant to that order, my lord will see that the proposal for
Order, my
co-creation,
lord,
along with the checklist.
There is a 14/5 order of the honorable court, my lord. 14/5 order, there is also, I think, mentioned 14/5. Proposal was sent.
That speaking order is placed before this one.
What is the date of the speaking order? 11/6? 24? No. What are you? What is the last? But the contender has held that the petitioner is eligible for being post or now for being appointed as teacher or tutor.
Tutor.
As tutor. And the proposal, and accordingly, the proposal has been sent to the secretary to the school education department, to the secretary to the Government of Assam Department of School Education. And thereafter, the secretary has forwarded the proposal to the finance department for creation of a post.
For concurrence and creation.
No, for concurrence and creation of post. And thereafter, the finance department has re-endorsed the file to the secretary or
To
director,
the secretary again,
to the secretary
to obtain department.
to obtain and obtain opinion of the judicial department, and the file is now lying with the judicial department since
9/6/2025.
9/6/2025.
Five.
Accordingly, taking note of the submission of Mr. Mosik, learned counsel for the contender, Ms. S. Kaur, learned government advocate, who is present in the court in other matters, is directed to obtain instruction about the current status of the said file sent to the judicial department. What is the number of the file?
The file number is not mentioned below the application. But I have given him her a copy below of the letter by
Maybe
the.
if file number is not there, then how can she will obtain?
I'll get her a copy below. She's also this animal of department. She can get.
Okay. Ms. Ward shall obtain necessary instruction and apprise this court on February next week.
Copy of the order, Lordship, one copy of the order is before the applicable instruction.
A copy of the order will furnish to Ms. Ward during the course of the day. 25th.
I'm grateful for that. Lordship, here, the, Lordship, it is on the verge of completion.
Again, has written to the deputy inspector of school for resubmit some.
So just a small exercise needs to be completed, Your Lordship. It is there, Your Lordship. That once again requested to submit necessary clarification regarding the ratio at which the family pension in respect of late Bhavakanto Datta should be shared between Srimati Dibyalata Hazarika and 3 children of Srimati Jyoti Datta to this directorate for disposal of the matter at the earliest as per the direction of Honorable Court. So one reminder has been sent. So my senior brother just obtained the clarification because it is not within our domain to do this. The concerned department, they have to, because the petitioners has to come there and attend and
I have already attended, my lord, in the office of the DI, my lord. I asked my client petitioner to reach the office of the DI, my lord, and accordingly, she told me that she had gone there and submitted that daughter already major and merit daughter, and another son is already major. Now another son, third number, he is to attain majority. 1 year left, so he will get. A day before yesterday, 3 days.
Then perhaps they will do the needful and send to us.
Now one son will get.
Okay. Or Mr. Allah, learned petitioner and Mr. Devi for the respondent number. You are here, respondent number.
Lordship, I'm for.
You are not here.
He for 2, I for 1.
Yes, I'm for 2.
Okay, respondent number 2 and Mr. Assembly system for respondent number 1. Mr. Devi is produced one letter of the Director of Pension dated 16/10/2025, addressed to the Deputy Inspector of Schools, Sibsagar, for submitting necessary clarification regarding the ratio at which the family pension in respect of late Bhabakanto Dutta should be shared between Srimati Divyalata Hazarika and our children. And the said instruction.
কোনো problem নেই।
No, said clarification has not yet been received by respondent number 2, for which the pension could not be finalized. The learned counsel for the petitioner submits that 3 days back, the petitioner has appeared before the DI of school, Shivsagar, and provided the necessary information to the DI. And at this instance, Mr. Sisti submits that he will obtain necessary instruction and advise this court on next day. Accordingly, it is provided that Justice shall list the matter on. After 1 week? Yes, after 1 week. Okay.
The date may can do.
Sorry. 26. 26, the letter produced before the next area and we take the-
Now, my lord, in the new order, correction order, pension order will be corrected and one's hand will get share. And the other two may get some share from the arrear amount because there is arrear of 3 years.
That will be decided by the DI of.
That will be decided by TI. Obliged.
Might be there. However, in this case, affidavit has already been filed, but I think not on the record. Was 12th, however, it was filed on 12th. For both the.
Another case for the petitioner on cross, however, Mr. B. Goswami, counsel for the contempt note. Submits that one affidavit has already been filed, but the same has not been placed on record. Accordingly, it is provided that Justice shall list the matter on 1st of December. And also shall take the affidavit filed by the contempt note with the record.
Obliged.
May I please, Your Lordship? Lordship, this is the review petition, my lord. This review petition against the Lordship's order. Lordship will find that order at page 21, my lord. The operating portion is started from 25, my lord, paragraph 6, my lord. At page 25. Here, my lord, it has been stated that I am reading that the counsel for the petitioner further submits that the respondent authorities have filed their affidavit in opposition and pursuant to order dated 27/8/2025, Mr. Das London Standing Counsel for the respondent authorities has obtained instruction regarding vacant post and submitted a copy showing vacancy status in Polytechnics of Assam as on so and so, which shows that no posts under civil engineering department are laying vacant, and as such, the pair for the petitioners in the WPC number 2651/2025 could not be considered due to want of vacancy in civil engineering department, as both the petitioner in the said petition belong to civil engineering branch and industrial and production engineering branch, and as such, their pair cannot be favorably considered. And accordingly, my lord, that pair has been rejected by paragraph 10. Here, my lord, there is a two petitioner. Petitioner number 1 belongs to the civil engineering. He is not entitled. But petitioner number 2, the present petitioner, he belongs to the mechanical engineering. He has completed his degree from mechanical engineering and he was serviced as a lecturer as mechanical engineering department. And my lord, he has been removed from service as a mechanical engineering. That has been wrongly considered, your lordships. I have annexed all documents. My lord, kindly peruse the annexer 1 at page 15, my lord. It is true that, my lord, initially, my lord, I have joined in the Karimganj Polytechnic as per the appointment made by the Director of Technical Education. in the Department of the Industrial and Production Engineering. But later on, my lord, after three months, my lord, I have been transferred to the Silsor Polytechnic, my lord. I have annexed all documents.
Now, which part of the order is required to be reviewed?
Paragraph 6 and 10. Paragraph 6, it has been considered that the petition number 2 belongs to the Industrial and Production Engineering branch, and accordingly, my lord, that has been dismissed at page paragraph 10.
So instead of civil engineering branch and industrial and production engineering branch, it should have been mechanical engineering.
Yes, my lord. My lord, in respect of the petition number 2 in that particular writ petition, the petition number 2 belongs to the mechanical engineering. He was not in industrial and production engineering. And in the mechanical engineering, 4 posts is laying vacant, my lord. As per their instruction, that instruction also I have annexed, my lord, at page 20. Similarly, my lord, other case has been, this is the joint order, my lord. It is a common order. In the other case has been considered positively, my lord, by paragraph 11.
In paragraph number 10, which part?
Entire paragraph, my lord. In the present case, the respondent authorities have not disputed the present petitioners are also similarly situated with the petitioners of the writ petition number so and so. The vacancy position is as indicated as in the annexure 2 of the additional affidavit of the respondent authorities indicate that 5 posts are laying vacant in electrical engineering department in several polytechnics of Assam. However, the said vacancy position does not indicate any post in civil engineering department. Under such circumstances, the pair made by the petitioners in WPC number 2651 2025 cannot be considered favorably, and accordingly the same stand dismissed. However, the writ petition number 2665 2025 stand allowed.
Then show me the document where which indicates
Yes, my lord, I am
the
showing
vacancy position in mechanical engineering department.
that is lordship will find at page 20, my lord.
Page 20.
20. This is the annexer annexed by the respondent, my lord.
Mechanical engineering department, 4 posts are lying vacant.
Yes, my lord.
Whether this document was enclosed with the.
Yes. All documents which I have annexed in this review petition, all were available in the writ petition, my lord. Annexer 1, the present annexer 1.
Mr. Upamanyu, is there any dispute regarding this?
No, lordship.
Pardon?
No, lordship.
No.
It might be the petition.
Okay, we'll pass the order. Next.
36.
Obliged, my
lordship.
Your lordship. Lordship, this is contempt matter and notice has been served to the sole respondent, lordship. As per office note dated 14/11/2025, lordship. 14/11/2025.
There is no office note dated 14/11/25.
Lordship, 12/11/2025. Sorry, lordship. 12/11/2025.
Any standing counsel for Bodoland University?
Lordship.
Oh, no, Director of Bodoland. Director of
Education, Bodoland,
BTC.
Lordship.
Is he available in the court today?
It's almost 4:30, Lordship.
4:30
But may fix on next week, Lordship.
next week.
The service is already complete.
Pardon me, sir.
Arshia, Lordship.
R. Sharma, learned counsel for the petitioner. Petitioner dated 12/11/2025 indicates that edit card issued to the sole respondent returned after service. But no one entered appearance on behalf of the sole respondent. This is the matter on
December.
part of December.
Lovely, Lordship.
Item 40.
May I please, Your Lordship? Lordship, as per last order, notice step has been taken and notice has been issued, but respondent number 6 notice came unserved. We may be allowed some time to take phase steps.
Pardon, miss?
As Begum. As Begum.
Learned counsel for the petitioner. Office note dated 13/11/2025 indicates that service in respect of respondent number 5 has been completed. Office note, no, not office note, it is as per order of laws in the court. But the said order also indicates that service in respect of respondent number 6 returned. No, notice issued to the respondent number 6 returned with the postal remark RTS. The learned counsel for the petitioner submits that she may be granted some time to obtain to take
Yes,
best step upon the respondent number 6. Fair allowed recessal is another after 4 weeks. Step be taken by registered post with alien also by usual process within 2 working days from today.
Lordship, can we allow 2 weeks time? 2 weeks time, Lordship.
No, we allowed 4 weeks time, but you have to take a step within 2 working days from today.
Okay.
That means within next Tuesday, you have to take a step.
Obvious.
May it please, Your Lordship. Lordship, in this case, petitioner was suspended, my lord, by the incompetent authority. My lord, by order dated 3/11, asked my learned friend to obtain instruction and also considering interim order, my lord. Now, my lord.
Filed one affidavit today morning, my lord.
Pardon?
I have filed one affidavit today morning, my lord.
Today?
Yes, ma'am. So.
My lord,
it
I am
not
having
really
the
record.
copy. My lord, if my lord goes to the affidavit, it is, I think I have no need to file reply also. Because they have admitted, director is unknown about the suspension. My lord, director is not known about the suspension.
Let it be in the next week.
My lord, in the meantime, I have also taken Dusty survey. That affidavit is there. So my lord, service is complete. So for admission, my lord.
Mr. Khandekar, learned counsel for the petitioner. Ms. N. Futon, learned standing counsel for the respondent in Elementary Education Department. Mr. Khandekar, learned counsel for the petitioner, submits that he has served the notice of respondent number
6, my lord.
Respondent number 6 by Dastimud, and he has also filed one affidavit to that effect. And as such, Mr. Khandekar submits that service completed. The matter may be listed for admission hearing. Ms. N. Futon, learned counsel. The standing counsel for the respondent authority submits that she has filed an affidavit in opposition today morning, but the same is not placed on record. Accordingly, it is provided that basis and list the matter in the admission column on
No, my lord.
Sorted.
My lord,
next week.
Next week.
26. Next week,
Next week, method, some urgency.
2-0.
I am deeply obliged.
Any other method?